I should just come in here right when I got in the building and then
Send you the spread from the cheat sheets.
Okay, have that. That'd be great. Thank you.
Okay.
All right,
All right.
we're good. A technical delay. The YouTube stream should be up and running for members of the different legal teams who were trying to observe this without having to come all the way to Fulton County Courthouse. For those who are just joining us, we did discuss intervention. I am permitting the interveners to intervene, that is over the objection of the State Election Board. I have consolidated the two cases that the Cobb Board of Elections and Registration brought. There was consent from the State Election Board on that. And the State Election Board has waived the 20-day window to have a bench trial on the declaratory judgment action brought by the Cobb Board, not brought by the other interveners, but I'll navigate that. We talked briefly about the motion to dismiss that the intervener Georgia GOP had brought. And then I was asking Mr. Thomas to share with me on behalf of his client, the State Election Board, why a timeout, a temporary freeze and non-implementation of these rules that were passed so close in time to the election, which has started today for early voters, doesn't make the most sense if everyone's commitment is truly to elections that are fair and carefully and thoughtfully supported by the many people who volunteer their time and get paid a little bit to serve as poll workers, superintendents, et cetera. But Mr. Kaplan mysteriously is at the podium rather than Mr. Thomas.
Oh, sorry. I thought you had reserved that question for later, Your Honor.
No, I wanted to hear up front because there's sort of, to me, that's the threshold. And Mr. Thomas promises he'll get there, but he has a capacity to sue, argue, saying surely someone, whether you're hearing it tomorrow or the next day, has capacity to bring the very same challenge that we've gathered here today to discuss. But I am open.
I am going to address just very quickly the capacity to sue argument, because I do think that we may get bogged down a little bit when we start talking about the hand count rule specifically. But county election boards are creatures of the legislature, and as a result, unless they have the express or explicit authority to do so as granted to them by the legislature, they cannot sue, much less sue their creator. Powers as are expressly delegated to them by the legislature. They possess no inherent powers. And a grant of power to a creature of the legislature is required to be strictly construed. And if there is a reasonable doubt as to the existence of a particular power, this doubt is to be resolved in the negative. The question is, does the county board have the capacity to sue? And the only recognized exception by the Georgia Supreme Court to this authority to sue position is that if the legislature either explicitly provides them the right to sue or grants them with the power, quote, possessed by private corporations performing similar functions, in those circumstances, they have the right to sue. In the pool case, in that case, the pool filed a constitutional challenge to an amended piece of legislation. That amended piece of legislation was going to increase the rates they were going to have to charge to their members and things of that nature. Similar arguments to the types of financial or logistical strains that are discussed by the petitioners today. But the court held, despite the fact that the legislature had granted GIP the authority to sue and to be sued, because it had not granted GIP the rights afforded to private corporations, it could not sue the legislature. It could not challenge the constitutionality of a statute. And the same is in the Hospital Authority of Wayne County.
So it wasn't that they couldn't bring a suit. They were empowered to bring certain suits, but you're saying not only does the legislature have to say you can sue, but either you are a quasi-corporation, so you've got all those rights, or I guess the legislature could say you can sue to include the ability to challenge the validity of a rule that was passed or handed down that governs your conduct.
That's right. And what we'll end up talking about here in just a minute is that they did that with respect to the state election board. They did not do that with respect to superintendent. In the Hospital Authority of Wayne County case, this is a 2023 case in the Georgia Supreme Court. They were dealing with a certified question from the Northern District of Ohio with claims against opioid manufacturers after the state of Georgia had settled with opioid manufacturers and issued an act that said you can any governmental agency in effect has waived their right to continue to pursue opioid manufacturers. The hospital authority said, wait a minute, you did grant us authority to sue and you did give us the powers of a private corporation. But the Georgia Supreme Court, in affirming GIP, discussing some of those cases, said, it doesn't matter, you're a creature of the legislature. And in enacting this waiver, it doesn't matter if you've already sued and these are pending cases. You can't pursue those and you can't pursue anything else. We have the power to constrain you. And obviously that brings us to today. And I've got the Cobb County Board of Elections is an instrument of the state, obviously. And it was created by the passage of a local act. And 240, when it said that these county boards will be created through local acts. And I've got the enabling legislation here for Cobb County. And I can give that to Your Honor if I can approach.
Sure. Thank you. Bless you.
So, and it says nothing about them being granted the rights of a private corporation. And in addition to that, the duties and responsibilities of the superintendents are set forth in the election code and OCGA section 21270. And it says nothing about having the rights of a private corporation. So attendants, the authority to sue or the powers of a corporation, but did grant the SEB the right to be intended for the superintendents. The county election board case should not be here at all.
What is the provision that gives the state election board the right to sue?
That is OCGA 21232.
Okay.
And unless you have any further questions on that, I'm done speaking about that, and I can move on, or if you would like to hear a response.
I'll hear a response in a minute. I guess the basic policy behind that is just the government shouldn't be suing the government. And so the legislature will decide these are the actors within the constellation of agencies that were all part of the same team. And so that would be the attorney general or someone else empowered to bring a suit who can do that. Maybe on your behalf, state election created by the legislature have only the authority we gave you, which doesn't include that particular a local election board. It might be able to lodge a claim or a complaint with the state election board or tell local legislators we've got this issue, go to the attorney general, but not on their own bring a suit.
That's correct.
Okay. Even as to which way to go. I will run the risk. There's no relief afforded a local election board, even though they might run the risk of being suspended, criminally prosecuted because they feel like the way forward is sufficiently unclear.
That's correct. And that's exactly what the legislature intended. You see that intent based on the fact that The
Well,
SEB
I'm
has,
assuming they didn't intend people to suffer under lack of clarity, but
No.
they gave the SEB, hey, if you've got an issue, you can sue. So they know how to delegate that or imbue an entity with that authority. And that's not what was in either the enabling legislation or just elsewhere in Chapter 2 of Title 21, that PS superintendents could bring a suit if they can refer something to the district attorney if they think there has been fraud in the course of an election, but they don't themselves take it upon themselves to take action, like refusing to certify or bringing a lawsuit.
that's correct, Your Honor. And with respect to your position or your question, they can't even bring a declaratory judgment action, saying that the SEB exceeded their constitutional authority, in effect, by passing constitutional perspective as well. But regardless, they do not have the authority to sue under both. And by the way, I've got the Georgia Supreme Court cases. I can give those to you now.
Sit down. Well, I guess why don't I hear from Mr. Kaplan on that?
Mr. White.
Or?
Yeah, Your Honor, I'm Daniel White. I'm gonna, we get this, we get this question as a local board from time to time. So I'm prepared to address that. Yes,
All right, Mr. White.
thank you. Let me just start by distinguishing the Wayne County case. That was a very specific,
Do you have a site for that? And this may be in things that have been filed. I hadn't come across that. I don't need a copy of the case. I just need the citation.
yes, Your Honor, I've got it right here. It is 317 Georgia 182.
So that's not an old case.
No, it's a 2023 case. A statute where the legislature, the settlement acts are to take away powers.
Sure, an extreme example of, hey, by the way, anything you might have been doing is extinguished by the. I appreciate Mr. Thomas's point, which is, hey, there's a group that had the authority to sue, and they could have it stripped away by the passage of an act, and in a way by the legislature, because you're a creature of the legislature, but your client doesn't have it to begin with, so we don't need to cast around for that bill that was passed that said, but you can't sue about the hand count rule.
Yeah, and I understand, we understood he would likely bring that argument. And honestly, if he gives you the other sites, you'll see most of the cases, school board cases, there's a whole slew of them that talk about the school board's not the right person to sue. Maybe you could sue a school district. So usually the capacity to sue or be sued is a discussion around sovereign immunity. A lot of times you see Cook versus Colquitt County Board of Education, that's 261 Georgia 841. That's the type of case you typically see on these capacity to sue or be sued. Under Cook, where they say you have to be granted that authority because it's a creature of the legislature. Also then applied from the other side against, when we're talking about a local light and water board. Fitzgerald, there's a Clark versus Fitzgerald Water, Light and Bond Commissions. That's 284 Georgia 12, and it in that case, the court said just because the board has the power to contract doesn't necessarily imply the power to enforce it. But importantly, in that case, the way they got there is to distinguish it from the Cravey versus Southeast Underwriters Association governs the SEB's board, the Cobb County Board of Elections capacity to sue. That's 214 Georgia 450. So it's an older case, but there's some other cases after it. And those cases talk about that it says the power to sue does not have to be expressed if it's implied by necessary implication or right. And so while there's not either in the enabling legislation that's been brought to court today or in 21270, which is what lists out the powers of OCGA 21270, lists out the powers of the county superintendent. The express or the similar language that's in the enabling statute or in the intervention and participation in litigation, that statute that he cited to you for the state election. But if you read through the enabling legislation, and I'll get to some specific provisions, and also 21270, we think it's implied. And not only that, throughout the election code, I think it's probably a little surprising for your honor to hear today that a county election board can't be in court, because I'm pretty sure you writ petitions to keep polling places open. And so the idea that, that this local election board can't be in court is sort of every single election we're in here asking for.
But that doesn't mean that you had the authority to bring it. It means no one challenged the fact that it was brought. And I don't know who's going to show up saying, no, close that polling place early. So it could be that you had looking for something. It sounds like as concrete as it will be by implication, boards would have to local election boards would have to have the power to sue. Obviously, if it was item 9 in 21-270, then Mr. Thomas, in contrast to the state election board, although it's not listed, the state election board's enumerated powers doesn't include that. It's a separate statute, no less explicit, that says you can bring a suit.
Right. And I think if you look at the Cravey case and the sort of the line, the powers and necessary implied. So that was one example, the precinct opening petitions, where we're in court on the appeal of voter challenges. We're in court on the appeal of candidate qualification challenges. That's 21-229, 21-230, 21-226. We're a necessary party in election contest, 21-520. So, and there's other places all throughout the election code where the county boards of elections are in court just all the time. And so the enabling legislation that he brought to court today, Georgia Law 1985, 4653, and does empower the board to, quote, to otherwise take such action as is appropriate to the management of the affairs committed to its supervision, provided, however, that no such action shall conflict with state.
That you just read.
9B and 9B.
I'm sorry, the law just lists sections. So which is the one that says they can do all these things as necessary to, you just read, Bill, and it's broken down into sections. So what section is that in? I'm just N90, like there's no N, 9B.
9B.
Got it.
9B. Your Honor, there's also, actually, there's been 3 amendments to the legislation that the more recent 2 just have to do with staggering board terms or changing the links. But the 1990, Georgia Law 1990, page 4006, allows the board to retain services of its attorney agreed upon by the board at an hourly rate determined by the board, and such compensation should be paid by county funds. So that's like sort of saying, hey, we know you're going to be, and then so all of those powers, along with the board's duty in OCGA 21-270, parentheses 7, to make and issue such rules, regulations, and instructions consistent with the law as he or she may deem necessary for the guidance of poll officers, custodians, electors, and primaries and elections. So that right and duty, along with, and here's probably our strongest thing here, Judge, the Floam case, which you're very familiar with, just very recently said, given, and a footnote, given the Board of Elections, Cobb Board of Elections, duties in administering elections, that is the kind of uncertainty that would support the declaratory judgment. And so what they were responding to was an amicus brief that we had filed in the Floam. It's really important that we get this right. We're being told by county commission we have to use one map, by the state legislature and its council that we have to use another. AG's office is telling us something, we'd like an answer. And the court dropped a footnote and said, if you need an answer, Cobb Board of Election, you're the right party to bring a deck action, which is, I mean, frankly, what led this board to pursue this in the first place. We learned from sitting around and waiting for the wrong party to bring an action that, you know, we need to come in and get this answer ourselves so my client can get it right. And so all of these things taken together, all the things listed in the enabling legislation and throughout the election code, along with the footnote in Floam, would support the power to sue and seek guidance, especially on this, when my client's being told this is how you have to apply the election code. And we have the state's top authority, legal authority, saying these rules that you're now being asked to enforce may not be valid. We've got to be able to give guidance to our poll workers, and to do that, and in order to do that, we've got to get guidance from the court. And I also just want to note that in Brooks versus Brown, 282 Georgia 154, and an election board, local election board, brought a declaratory judgment action. It was ultimately dismissed as moot, but there was no suggestion that it didn't have capacity to sue. So I think looking at all those things together, Your Honor, there's under the Cravey rule, I think about a necessary implication. I think it's clear that my client's permitted to be in court under a necessarily implied power.
How do you spell Cravey?
Cravey.
Okay. 214 Georgia 450.
Yes, Your Honor.
Got it. Thank you. All right. Mr. Thomas, if you would please tell me why, setting aside, you sort of have 2 walls you've built now. One is, hey, the Cobb board can't bring a lawsuit anyway, and these interveners have come in too late. So you am objecting to having to deal with their substantive claims. So I get why, in theory, what might flow from today is no authority to sue on behalf of the Cobb board, and we don't reach the merits of the interveners' claims. We still have the TRO as adopted by the interveners. And so that's what I had asked you, sort of having dessert as the first course. Why wouldn't we just pause, especially on the hand count rule, given what looks like a fairly robust record of chaos that it is sowing? Why wouldn't that be the prudent thing, that a state election board that is committed by its charter, and hopefully all its members share that view, of having orderly, non-chaotic, thoughtful elections?
Okay, and I will address that. I know that you want me to move on to that. I'm just
I
going
do,
to say
second
one
time I
thing.
asked.
One thing on standing, I just want to bring clear to the court, Georgia Supreme Court, in the Gibb case.
The Gibb case.
Gibb case, the
Oh, that's the,
Georgia Insurers Insolvency Pool case.
okay.
They held that that Gibb did not have the capacity to sue, to contest a statute on constitutional grounds or otherwise, despite the fact that the insurance pool was authorized as follows. The Georgia Insurers Insolvency Pool is a nonprofit legal entity with the right to bring and defend actions. And such right to bring and defend actions includes the power and right to intervene. So that language is in there, and the Supreme Court noted it and said, we note that. But because we did not grant you the powers of a corporation, you cannot sue us in the way that you have. And to address
What's the citation for that?
the statute
No, the case.
293 Georgia 504. It's a 2013 case.
Thank you.
And to the extent that they argue that Section 9, which says effectively that you have the right to do such other or take such other actions as are incident to the management.
Right, the usual catch-all. We can't list everything. If you need to buy staplers, you don't have to look for.
Correct.
It doesn't say we can buy staplers.
That's right. But also 3336.6 contains effectively the same provision. It says that their charter, how they are supposed to act, can contain additional provisions in this decision. And the Georgia Supreme Court said, no, that's not enough. You cannot sue this way.
Okay,
So thank you for entertaining that.
thank you for bringing it up.
All right. The hand count rule. Number one, there should be no pause because the SEB is the entity that is tasked by the legislature with creating these rules. And nothing in the legislation says anything about any limitation on when those rules can be passed preliminarily. Two, with respect to the hand count rule, I want to make one thing very clear at the outset. This is not the counting of votes. This is the counting of ballots.
I think that's important to make clear, that it is simply how many pieces of paper are here and not on each one. That was a vote for McBurney. That was a vote for Tom. But it's not counting the results. It's counting, but it is nonetheless manual counting of pieces of paper after the polls have closed in a way that hasn't happened before.
Well, that's not true
Well,
because
it may have happened that way a million years ago, but is not the way elections have been conducted most recently, nor have people been trained on doing it this way.
right. If you mean as it relates to counting of votes, yes, that's true. As it relates to counting of ballots, that's slightly different. And there have been counties as the administrator of ballots to reconcile against what the machine says were the number of ballots that were cast. But I want to make that clear because when I read the news and I see how this is characterized, I think there is confusion there. And this is not votes. The poll managers, the individuals that are counting, cannot touch the memory card except to place it in an envelope. And the votes that are actually tabulated are those that are on that memory card. All we are doing is saying you need to have receipts of votes cast mirrors the number that the machine says were cast.
A laudable goal. My question wasn't who thought of this, what was the idea behind it? And I think there is much votes.
Right.
And so in this stack, there were 100 for Smith and 12 for Jones. It is simply the machine says there were 800 ballots that were entered. Let's make sure that there are 800 receipts, because if they're 790 or 810, something is off. But it is still a hand counting. It's a touching of these laudable or not. That's not my focus either. It's why shouldn't we wait until all the training has occurred and questions can be answered? Because in the same way that there is misinformation about what is this process, there seems to be misinformation about there are people obstructing. There may be, but there seem to be a whole lot of good faith to do it. Most of my poll workers are over 60. They go home at 8 o'clock at night. And so then if we're going to do a hand count, it's going to be the next day. Uh-oh, the place where we would have to count it is an hour away from that precinct. And a lot of my poll workers, they took the bus to get to out of what would be a zillion permutations of you just drop this in my lap and there's not a way for me to be confident that I do this in a safe way, not in terms of people being in danger, although that specter has been raised, but in a way that's accurate and consistent with the fidelity that I think is honestly behind ballots cast, that there are in fact 800 receipts. Laudable goal. This seems to me like late in the game, and there's no deadline that anyone's violated. I'm asking you from a practical perspective, if the goal is orderly, reliable elections, why the prudent, in terms of reasonableness, approach wouldn't be to say, let's try this next election, when all those questions can be answered with no one having to sue.
Right. And I think that what hypothetical predicated on speculation, predicated on conjecture, and that is not appropriate to declaratory judgment, which we will address separately, but that's all it is, a mere concern. If you read the affidavit that was submitted by in Cobb County, every single allegation that they make where they are expressing harm is prefaced by either concern that or I worry that. It has to be more than that. Now, with respect to the rule, the reason why we shouldn't pause is that the requirement to do this and the time that it would take to do this is complete.
That be speculative as well, because it hasn't happened yet. And so you are saying, you know what, these things that the people who actually do this, I won't say for a living, but do it, this is their responsibility they've assumed for the election, are saying, here's how this is going to play out. I don't have a crystal ball, I can't prove it to you, but aren't they in a better position to say this is going to be a problem than you saying it's not going to be a problem because I just know?
That would be an example of a county election board or a poll worker attempting to substitute their judgment for the judgment, number one. But number two, it's not speculative because in the affidavit that was provided by Cobb County, they did the math for us. They said, quote, it took approximately 1 hour for 3 people to independently count 2,000 ballots in stacks of 50 as required under the hand count rule, approximately 33.3 ballots per minute. Okay, so that's their math. Election day in Cobb County, the third most populous county in the state of Georgia. There are 4 ways to cast a vote. You've got absentee ballot by mail, you've got advanced in-person voting, you've got election day voting, and you have provisional ballots. There were 390-something thousand votes cast back in 2022 and approximately, well, a fair amount less than that back in 2020. The overwhelming majority of those were cast either as an absentee ballot or through in-person voting. The only counting that is done on election day is of the ballots that were cast on election day. So in Cobb County, if we're to look at those 2 years, votes cast, 149 or so were by absentee ballot, 174 by in-person ballot, and 71,000 on election day, divided among 145 precincts. In 2022, there were 25,246 absentee. There were 181,386 advanced in-person votes, and on election day, there were 106,085. So let's do that math based on the numbers that they provided in the dry run. In 2020, with those 71,000 ballots that are counted, at 71,000 divided by 145, that's 490.5 ballots in effect, on average per precinct in Cobb County. That takes, using their math, 14.7 minutes. With respect to 2022.
Is there a reason to assume that it would be distributed so evenly so that it's however many minutes you just said, 14 minutes per precinct? Or does the data show that more in-person voting on the day of election than others? And so in some places it could be hours, and in others it might actually only be 2 minutes.
Right, and that there were some counties that would have more than 750 ballots that were cast, but there's no further information as to a breakdown precinct by precinct. But on average, 490, which would have taken 14.7 minutes. In 2022, it would have been 717 per precinct, which would have taken on average 21.5 minutes. That's it. And this is the third most populous county in the state of Georgia. And so all of this argument that has been made that it might delay certification, which happens 6 days later. I mean, you know, the math that they provided reveals that that's absurd. And it also would not conflict with their the superintendent's statutory requirement to provide the unofficial votes tally by midnight, because the poll manager is permitted to send the tabulation tape and the memory card on to the election office so that they can be used to be reported. So there's no conflict with the certification, and there is no conflict with the election night unofficial results report. So in terms of why there shouldn't be a pause, it's because what has actually been asked of each of these precincts is not hundreds of hours of vote counts. It is, using their math, 15 minutes or 22 minutes on average.
Quick question, and thank you for that. One of the concerns I read in the materials for this case, I think you've just addressed that this 11:59 p.m. deadline to communicate certain results the day the hand count doesn't interfere with that because that data can be transmitted, even though we might have a precinct where it's 800 that need to be counted. And so people say, we're gonna go home. It was a long day. We'll count these tomorrow at the tabulation center. That's 30 minutes from here, but everyone's happy to go do that. And they do it. We'll call it midnight deadline, day of.
No, there's not. And
Walk
it
me
is,
through that again. You said it real quickly and I was writing down something else.
this is in 183.112.12, the tabulating results regulation, and it is subparagraph 7. And it says that the last sentence, the election superintendent in his or her discretion may allow a designee of the poll manager to deliver the envelopes or containers containing the ballot used for unofficial reporting of results. So the regulation is there to recognize the fact that sometimes things can take a little bit longer, but in order for you, superintendent, to satisfy your requirement, you can authorize that those are delivered separately from the paper ballots and everything else that's identified in that regulation.
Okay.
Thank you.
All right, Mr. Kaplan, when you're ready, we can, that was substantive and helpful and will help me process what I expect is coming, but let's pivot now to your client's concerns.
Thank you, Your Honor. With the court's permission, could we use a PowerPoint
Sure.
to assist me in the presentation? We're going to go ahead. and
Yeah,
try
if
to-
you're in the Zoom, was the Zoom, if
I
you've
think we
got
have
it.
it all set up. I think
Okay.
we just have to get it and make it live. The other point of housekeeping is the parties have reached agreement with respect to the admission of petitioners' trial exhibits. These are petitioners' exhibits 1 through 22. And I have a binder of these exhibits. But I would ask that counsel for the state election board confirm that we have a stipulation of the admission of petitioners' exhibits 1 through 22.
That was my understanding. Is that right, Mr. Thomas?
Yes, Your Honor.
Great.
Would the court like a copy of this binder?
That would be helpful. I have them electronically, but this machine's not talking to that directory. So, thank you.
Yes, indeed. And I'm also handing the court a binder of authorities and pleadings that I may refer to during my argument. I've also provided that to counsel for the respondent. And this just has some of the, election statutes that we've talked about and the pleadings in this case. Before I begin with the presentation, Your Honor, I just want to briefly respond to the argument, if you don't mind. And I think that in terms of ability to sue, I don't think the court has to do a whole lot of homework to address this issue. The cases that were primarily relied upon by the respondent address a creature of the government attempting to challenge the constitutionality of a General Assembly law. We are not here challenging the constitutionality of any law passed by the General Assembly. I think I would agree that we couldn't do that if we tried. But there's no question that the election board has the capacity to come into the courthouse. We've been doing that for many decades. The only question is, how far does that go? And in the last case that was cited by the respondent, I think it draws the line exactly right. This is the Georgia Insurers Insolvency Pool case, 293 Georgia 504, which also held, as the respondent argued, that in this case, the public entity could not challenge the constitutionality of a state law. Well, that's right. That's a rule of law that's been in existence for many decades. But what this case also said is that the power to sue and be sued was given only to enable GIIP to bring and defend legal actions pertaining to its statutory functions and duties. So there, the court recognized that GIIP could sue. It was just limited to getting essentially a court resolution of its own duties and powers. And of course, it's an obvious proposition that an agency that derives its power from the legislature really can't sue to challenge the legislature's acts. We are not suing the legislature. We are suing another creature of the state legislature and asking for a court ruling as to the validity of rules passed not by the legislature, but by another agency. And that's why FLOAM, the footnote 7 in particular, the Supreme Court's most recent statement on this issue, makes this very easy for the court. And frankly, that decision, and this is tab 18 of the binder that I just handed to you, answers both the question regarding a declaratory judgment and the uncertainty that we as an election board face, as well as the question of capacity to sue. The footnote 7, the Georgia Supreme Court earlier this year says, given the Cobb County, I mean, this is talking about our county board of elections and registration, given BOER's duties in administering elections, that is the kind of uncertainty that would support a declaratory judgment. And the declaratory judgment was regarding the validity of a redistricting map, how we administer elections. So I don't think the court needs to spend a lot of time addressing either of the two issues that we talked about this morning, because the Supreme Court, thankfully, in footnote 7, provided us the answer. Now, we are not the only board also that is asking for court guidance on this issue. And Your Honor, we filed a motion yesterday asking the court to take judicial notice of the fact that the DeKalb Board of Elections, as well as the Muskogee Board of Elections, and these are differently situated boards, but across the state, suffer the same uncertainty that we do. And Your Honor is familiar with also who have the same concern. And so this is not like one rogue local election board trying to pick a fight with the state election board. This is a case where the chief legal officer of the state, the chief election officer of the state, that comprise different populations, different demographics, all have serious questions regarding how this election to happen in 2 weeks, and that is already happening with respect to absentee ballots and early voting, is to be administered.
But of all the rules, the one that seems to concern people the most is the hand count rule. And we just heard a fairly persuasive presentation as to why on the one day that it might involve, or maybe a day after, if there are too many ballots to be hand counted, again, just number of ballots, not contents of ballots, that's nothing that affects today. We could both go vote early, and the hand count rule doesn't implicate how today would be administered by a county board of elections. What is all the uproar about if it is as simple and non-impactful as Mr. Thomas described it? And he got down to not 14 minutes for the typical precinct in Cobb County. That doesn't seem like the type of imposition people need to say, stop, we need judges to get involved because we don't have 14 minutes. I'm sure it's more complicated than that, but that was based on numbers, not the speculation. It could be very knowledgeable speculation that this is going to get complicated because my poll workers, they're not going to stay late. It's going to be a long day for them. And they're already saying, if I have to be hand counting ballots, I'm just not going to show up.
That's fair. And if you don't mind, Your Honor, I'll walk through the rule because I think my answer to that question requires considering what the rule says. And so just to point out, as we stand here today, this rule is not in effect. And so to the extent that we request an injunction or a temporary restraining order, and we ask that the court maintain the status quo today is that this rule is not implemented. And I think that that's important because even though counties across the state are probably trying to figure out what preparations need to be made to comply with this rule in the event that the court holds it valid. It is not even yet in effect. And that's important to the legal analysis with respect to our request for a TRO.
And is that true for all 6 rules? They all have an effective date of October 22?
That is correct, Your Honor. The state election board noticed the hearing to receive public comment about these rules on August 21, that exactly 30 days before its hearing on September 20th. Its hearing took place on September 20th, and despite not giving the public notice about this, it voted to approve those rules. The Secretary of State then, as you see on the screen, Exhibit 15, published these rules, and the date of publication is what triggers the rules. I think it's 20 days from the Secretary of State's date of publication, which is October 22nd. So that is next Tuesday, which means literally 2 weeks before the election to follow 2 Tuesdays later.
Okay.
So to answer your question about, well, is this really that big of a deal? Let's walk through the language of the hand count rule. The hand count rule requires that 3 poll officers hand count all paper ballots that are fed through an optical scanning machine.
On election day.
Either on election day or
Oh, I didn't ask that clearly. It's only the ballots that were cast on election day. It's not ballots that were cast through early voting or mail-in absentee ballots, all the different other categories of ballots. It would be hand counting the ballots that were cast on election day. They may be counted later than election day, but it's only that universe to be very popular, an increasingly small percentage of the total votes cast in any county.
So I think the answer is yes, although the Secretary of State has not given us guidance on this, but we read the rule as pertaining to the ballots that are cast on election day.
Okay.
So the first answer to your question is we think yes, though we would prefer that the Secretary of State give us that confirmation. And also to in some way address some of the numbers that were used by the respondent. I don't think that we can fairly use the election results of, say, 2020 during COVID as a very good indicator of what the election looked like. Ballot casting in that election was substantially higher as a result of COVID.
And 2022 wasn't a presidential election.
Exactly. So those statistics, while certainly they're true and public, they do not give clear indication of what the rate of in-person ballot or in-person voting would be. I actually think it would be better to look at, say, the 2016 presidential election, which the respondent did not address and which is not in the record. So what is the rule? What else does the rule require? Well, the first part of the rule states that these 3 poll officers must count, quote, separately, unquote, and, quote, into stacks of 50. Now, the rule is not clear as to how this count should be performed. Does the term separately mean that poll officers must count all 2,000 before the next poll officer counts and stack, each into 50? Because if that were the case, it would take a whole lot longer. The word independently is also used. So what is the difference between the requirement that the counting be performed separately and that the counting be performed independently? We also don't know these words and intended to create separation, to create independence among poll officers, but we don't really know what that means. Now, the count that officers was on a day when they had good sleep and hadn't worked for 15 hours was essentially taking a stack of 2,000 pieces of paper, sorting them into 50, handing them to the next poll officer, making sure those were 50, and they kept any count of stacks of 50 going on in probably the most efficient way possible. But we don't actually know if that would satisfy the state election board. We sure hope that if this rule were held valid, which we don't think it should, that we can count that way, because if we have to do it another way, where one poll officer has to do the whole count of a whole 2,000 statements about each
But what
stack,
would
et
happen?
cetera, we just don't know. We haven't been trained. And certainly we have a lot of fear about, well, are we doing this right? And are we doing this consistently with other ways?
What would the administrative procedure be if this rule were passed in February of next year? Or it was effective February of next year? I'll be familiar with the mechanism. Does a local election boards certify a question to the state election board? Is it the Secretary of State who bears the burden of coming up with the rules to implement the state election board's rule? I mean, who answers? Just take that one question. 3 different poll workers, you and I and Mr. Thomas, and then put them back together again, and then you count them all. It's a fair question, but how does that get answered? If this was February, we've got all the time in the world because the next election isn't forever.
Well, so as I understand it, and I'd welcome Mr. White to add to my answer, but as I understand it, in the normal course where, sufficient notices provides officer develops training materials and provides those training materials to superintendents. If there are, questions about how to do things, that's often the way it happens if there's not, significant legal questions.
But the training materials don't come from the state election board. They would issue the rule, and then the Secretary of State's staff would figure out what's the most practical way to implement this. In other words, what guidance would come from the Secretary of State to the local election board saying, here is how you separately and independently count.
Correct.
Okay.
That's one way. And that's typically how it's done. Secretary of State makes videos, poll officers doing things in the way that they're supposed to do, transmits those videos to election superintendents, if it's clear. Now, here, the Secretary of State has refused to do any training and has quoted the Attorney General's opinion that this rule is invalid. So we have no guidance, and we have not been able to obtain any information whatsoever from the Secretary of State. But that's the answer to my question is in a normal situation. I mean, separately and independently, if there was a question about what that means, there are other proceedings which, could take place to get more clarity. Of course, election boards or the Secretary of State or the Attorney General's office could interact with the state election board to ask for clarification if there were more time, if we needed to understand, those differences. But typically, the Secretary of State would lead the training process in advance of that office's responsibility to ensure an orderly election and ensure consistency among superintendents. Now, the state election code also grants, to some limited degree, discretion to the superintendent, meaning our local board, to deal with very, very specific issues. But usually we're talking highly, highly specific, because if you grant a superintendent too much discretion, then you have counties doing elections differently. And so, but what's remarkable about this rule is that it actually grants discretion not to the superintendent, but rather to individual precinct poll managers to decide when to do this count if there are more than 750 ballots. And so you have in Cobb County 148 precincts. And so there are 148 poll managers.
So a poll manager is a precinct manager?
Correct.
Okay.
That is exactly right. And under this rule, we have the concern that the superintendent, meaning my client, it doesn't even have the power to say, this is what we think this should be done on election night, or we think under these circumstances, you should do it on election night, or you should do it the next day. That power has purportedly been taken away by the state election board and then given to individual poll managers, not just the 148 in our county, but throughout the state. And they get to make decisions about when the hand count would take place, presumably regardless. Decision about when is up to the poll manager or even assistant poll manager. So that is, as I'll explain in more detail later, totally contrary to the structure of the state election board and to, the structure of the authority to administer elections in its own county. Now, in addition to that, to the extent there are discrepancies between the counts by either individual, poll manager is required under this rule. Again, not the superintendent, an individual poll manager is required to, quote, immediately determine the reason for any inconsistency, quote, correct the inconsistency if possible, unquote, and then document any, quote, corrective measures taken. And so once again, we have a rule where, what does this mean? Like, what is an immediate determination? Does the poll manager, what differences in what folks come up with? I don't want to speculate on what could happen. It's just because hopefully this would be a very...
I don't know, but if we put it in the context of what this rule actually does, which is said simply count pieces of paper. They're important pieces of paper, and there are questions about whether people should even be handling them. But set that aside. The inconsistency would be, I counted 700, I counted 702. It's not hey, that mark next to McBurney's name on the ballot, that doesn't look sufficient. And I know these aren't hand-filled out ballots, but inconsistencies don't involve what was the intent of the voter here
Correct.
or anything like that. It would be a numerical inconsistency. He counted 790, she counted 792. And they did it twice and they still don't match. So an example would be, I guess that poor poll manager has to then count them all. It's not clear. It's empowering people who maybe shouldn't have that authority. It is creating maybe in but one county, 148 different ways of doing things to resolve an inconsistency that can only be about the number of pieces of paper. So to help me appreciate the alarm about that, because the outcome would be, it sounds like a notation that would be transmitted to the superintendent. We can't tell if it's 790 or 792. There were more votes for McBurney than there were for Kaplan. And we just feel this looked like McBurney people coming into the precinct. And so we think
There's alarm. I think that the concern is that there has been no trainers or of our poll officers. We have never dealt with a situation before where poll managers suddenly have discretion like this. This is a new process that we
if
have
a
never.
poll manager wants to keep two machines broke down and the line is long, poll manager can't decide that. She has to get the superintendent to say it's okay, or that kind of authority. Is that a fair statement?
I think that's right.
Okay.
And so that's really, I mean, when we administer elections, obviously we take great pride in doing what we're required to do under the law, which is administer fair, accurate elections and consistent elections, consistent among our precincts and consistent among different superintendents. That is what the law requires. And we are in a situation where these requirements, you know, while it's theoretically possible to satisfy them, we do not have the training that gives us the confidence that this is how it's supposed to be done, whether it's with respect to how the count is to take place or how, you know, reconciliation should be done. And that is the problem that we face, is not that this is a bad idea, but that it is far too close to an election to be starting this process now. I mean, as their states, we started training last year. I mean, elections are very poll officers or I should say poll workers in Cobb County alone. That's because we have 148 precincts. And their training has been completed for the majority of our poll workers. And so to now have a new requirement that is unprecedented and that would take effect literally 2 weeks before an election, and we don't have the resources to do it, whether financial or the resources that we're used to having from the Secretary of State, who has declined, understandably, to provide any support to local superintendents or certainly to poll managers. And we're putting poll managers in a position, or this rule, I should say, for the first time, without guidance from either the Secretary of State or without guidance from our election board, and they got to figure it out. And they got to be concerned because, you know, they're responsible for the actions of their poll workers and they're responsible for following the law, and they're, you know, and our board is responsible for administering a good election. And so, you know, certainly we would never start 2 weeks before an election to train on how to do that.
Okay.
Communication that was made by the Secretary of State's office, this was just about a couple of weeks ago, just after the rule was passed or adopted, I should say, on September 20th, the Secretary noted the Attorney General's comment that the rule amendment, this is speaking about the hand count, was, quote, not tethered to any statute, legislation that agencies cannot do. And then went on to say, because the SEB rules are tied up in litigation and because poll worker training in many counties has already started and there is limited time remaining for additional training, the SOS Elections Division does not intend to provide additional training on SEB rules until after any court decisions are made. And I point out that that's not just with respect to the hand count rule, but it's with respect to all the rules. Of the view that rules should be passed 2 weeks before an election, and it simply declined to train on them due to its concern.
They were passed many more weeks before the election than 2. They're going into effect 2 weeks before the election.
That's a fair correction, Your Honor. Yes. review under the APA. And I'm going to move to the Attorney General opinion because it really answers a lot of these questions. But whenever the court is considering the validity of a state agency rule, it really asks two questions. And two is the rule reasonable? And most of the case law concerns the first element because it's very important that the legislature, duly elected by the citizens of the state of Georgia, be the lawmaker in Georgia. And our divided government, it makes the law. And agencies in the executive branch, but that rulemaking has to be limited by what the legislature has expressly authorized. And there's a further reasonableness component that is required to ensure that agencies do not act unreasonably. And here, both of those requirements are implicated, we think, because they're not authorized by state, are being implemented. Now, the rulemaking by the state election board is limited by the state election board's enabling statute. That's OCGA 21-2-31, which really has two components regarding rulemaking. The first is to promulgate rules and regulations so as to obtain uniformity in the practices and proceedings of superintendents. So, and this is a duty of the state election board. So it's not just a grant of rulemaking power, it's a grant.
They identified three, two of which you don't need to spend any time talking about because they don't involve hand counting. They don't involve what's going on election day. They don't seem to have any, they'd be part of the untethered. But the third one didn't seem to be fully untethered. And so I want you to explain, if this is the direction you're going,
Yes.
I'm not trying to pull you off course. I introduced to the hearing earlier today. You don't need to convince me that the first two statutory bases are insufficient.
Understood.
But the third one, there did seem to be some hooks. So let's talk about that.
Sure. 13-4 that requires the citation of sources. And just to order the court around this, I mean, we are not here based upon our own legal analysis. We are here based because the Attorney General has publicly issued a memorandum that analyzes the validity of these rules and ultimately concluded that they are likely unlawful, at least the
Paid in on 3 of the 6?
That's correct. The state election board, and I'm going to forward to these statutes, which are 436 and 21-2-420. And I think, Your Honor, I just want to make sure we're on the same page about which was section 483, which pertains to votes at a tabulation center. The Attorney General said this has nothing to do with hand counting.
I say it has nothing, also say it has nothing to do with hand
Okay.
counting.
And then the second one is OCGA 21-2-436, Attorney General ballots, which we don't even use anymore,
In most places.
as I understand, in all places.
Okay.
But yes, like we don't
Right.
use stubs and, and certainly this rule also discusses what is absolutely zero to do with counting after removing ballots from a ballot box. So I think the statute that might have some relevance here, as the Attorney General also acknowledged, which does pertain to the accounting and related documentation. And so this is probably the only rule that has like some theoretical relevance. Reference in this rule to anything even remotely approach.
Well, isn't the debate going to be what required accounting means? And if the state election board concludes that required accounting is reconciling the count of ballots cast registered by the machine versus the actual receipts, then that would be required accounting. Election board add meaning to required accounting. Clearly, the statute's not referencing that. It would be referring to elsewhere in the election code, whatever accounting is required by the Georgia election code for poll officials in a precinct to complete. And they're piggybacking this new thing. And so the debate is really, can you add to it? And is that, and did they exceed their authority to say required accounting means that which is elsewhere in the election code, the things you've got to do, one, because this is their +1. And if they can add a +1, it seems like 420 supports it. But some of the reasons why some of the other rules seem to be problematic is that the legislature has said, here are the 4 things that you do. There's a list. And then the state election board has said, well, here's a 5th. And there's pretty clear case law that says you don't get to add a 5th because we gave you 4. We didn't say, and anything else the state election board comes up with. It's these are the four things, whatever the number is. And the state election board is in effect through one of these other rules, adding a fifth. And that seems to be problematic. Here, the way I processed 420 is that if there's a hook, it's that the state election board is saying, here's what required accounting means. See wherever else there are instructions in the election code to poll officials, and then also add this hand count.
Yes, Your Honor. And first of all, I would just note that the chief legal officer of the state, the constitutional officer who has the authority and responsibility to determine that this statute does not authorize the state election board to create a new form of counting of ballots, that the hand counting of ballots is untethered to Section 420.
And the Attorney General's opinion, I'm not remembering the format. Was it a letter or is it an actual Attorney General's opinion? So that if we're looking through official opinions, which also is it's not a court ruling, but there are different degrees of oomph that the Attorney General can put behind his word. It could be a letter, and you ought not to ignore it. It could be an opinion, do that. I'm just not remembering what got sent.
Sure. It is tab 9 and this was a memorandum dated September 19th of 2024. It is 6 pages. It was sent by the Attorney General's office to the chairman of the state board.
Okay.
And, just to Your Honor's point, I mean, going to the sort of unusual nature of this process and the lack of orderliness required by the enabling legislation, I should say, notice on the very first page, the unusual nature of the request for a legal opinion in this matter. It's simply copied to determine whether or not the board has made a passing comment to see a particular topic, And so, and ultimately the Attorney General decided to make a quote, limited exception to its usual practice for the election board meeting. Despite the very unusual nature in which this came to the Attorney General's office, that was involved here, which is itself unusual, the Attorney General produced a very thoughtful and comprehensive 6-page analysis of at least 5 of the proposed rules and analysis addressing the likely illegality of the hand counting rule. But back to the question about 420, the Attorney General specifically addressed that and noted that it doesn't address the APA case law, HCA Health Services, as well as other case law within its memorandum that makes clear that an agency does not have the power to impose new conditions or new requirements where here, if you look at Section 420, there are some very important features of this statute that, in our view, reflect an inconsistency. Not only the absence of any authority, as the Attorney General noted, but actually an inconsistency with the hand counting rule. Subsection A of this statute requires that the chief manager, one assistant manager deliver a copy of tabulated results and then, quote, immediately deliver all required documentation and election materials to the election superintendent. It goes on to then require the election superintendent to ensure that such ballots are, quote, processed, counted, and tabulated as soon as possible and shall not cease such count and tabulation until all such ballots are counted and tabulated. This is a very clear expression by the legislature that ballots are to be delivered to the superintendent and counted as soon as possible, and that the counting cannot cease until it is complete. That is consistent with the way we have run elections for many years. We get the count done on election night by 11:59. We post the results, publicly, so that the post statistics. It is inconsistent to delegate to a individual poll manager.
Not immediate delivery. It's, hey, we'll get it to you when we're done with our work, whether it takes 14 minutes like Mr. Thomas forecasts, or much longer like some of your affiants forecast. Either way, that's not immediate. It's holding on to some things that A says you don't hold on to, and it's the superintendent. The word ballots is right there. That it's the superintendent who is ensuring that they are processed, counted, and tabulated.
That's right. An individual precinct level poll manager who's responsible for more than 750 ballots to wait, just wait till the next day and start a hand count then. That is totally inconsistent with the Georgia legislature's requirement that the counting not cease until it is completed. So it contradicts the legislative intent and the clear language of subsection A.
Do you want to talk about reasonableness more than you have?
Well, and the only other thing I'd say is subsection B says the same thing, Judge. That the superintendent is required, again, our board is required to ensure that the number of ballots cast number for the time of the closing of the polls in the last elected vote. So there's a clear mandate to get this done as soon as possible. All right. To my co-counsel, Mr. Suss, on the issue of reasonableness and the Purcell rule, I think what I'll do is turn to the exact compliance requirement.
Okay,
if that's
let's do
okay
that.
with you.
That's fine.
So, as I said earlier, the court need not actually, these rules are expressly authorized by statute, whether the agency had the power, whether they are reasonable, because the agency failed to follow the law in the way that the agency, the state election board, I should say, gave only 30 days notice, just enough time on August 21st to post these 6 rules.
Is there a case law that says exact means sometimes shall doesn't mean shall, and exact means kind of close, and some evidence means any evidence. And so I'm curious if there is a case that says the notice that was given by a board that was going to be adopting a rule said, today is just for comment, but instead they adopted, that was challenged, and an appellate court has said, that's not notice. More importantly, that's not exact compliance. And so the appropriate or an appropriate sanction is that rule is void or set aside or whatever the corrective action would be.
The answer to your question is we've looked and we haven't found a case exactly like that.
What's the closest?
The Walker versus Department of Transportation, which is 279 Georgia App 287, says, quote, the failure to comply with these procedures will invalidate an amended rule. So it notes the exact compliance requirement. The outdoor advertising case, which is tab 21 of your binder, is 186 Georgia App 550, did hold that agency rule of the Department of Transportation was procedurally invalid because it held a hearing, or excuse me, it held a vote earlier than the 30 days required by the statute. But I don't think Your Honor really needs case law to determine the meaning of exact compliance. I mean, the statute is very clear. This is subsection D, and it says very clearly, no rule adopted after 1978 shall be valid unless adopted in exact compliance with subsection A. But in this statute, substantial compliance is enough for some of the other subsections. So I don't think the legislature could have been any clearer that the requirements of subsection A, which include not just 30 days notice, but the additional requirements that I'm going to discuss, and a statement of the agency's, quote, intended action, is an exact compliance requirement. I mean, action is also something that's easy to interpret in terms of its plain meaning. What act are you going to do 30 days from now?
But if the intention was to receive comments and then there was just such an upswell of support for adopting the rule, hey, let's pivot. Everyone loves it. So now we're going to adopt it.
Well, that's not how the APA works, Your Honor. If no matter how much consensus there is, the agency is still required to give the public 30 days notice, because you can't be sure that you have everybody's opinion and you have properly notified. And this is because we're talking about agency rulemaking here. These are not elected representatives of individuals by either the executive branch or others who are essentially creating law. potentially. And so we need to ensure that the public is on notice of not only the fact that they're having a meeting, but what they plan to do at the meeting. And here, as the notice reflects, the only thing that the only action that the state election board notified the public that it would take at the September 20th meeting was comment upon and provide input into the proposed rule amendments. That was the purpose of the public hearing. And, you know, we're talking about a time when we're just a couple months before a presidential election. So I think a reasonable person reading this notice would think to themselves, okay, well, you know, the state election board is considering taking comments on these rules. It's interested in hearing what, you know, the public had that sentence, which I'll blow up a little bit more here, and realize that the action that the state election board intended to take at that September 20th meeting was to vote on the adoption of these rules. Many people may have not attended the meeting because they didn't really care to hear about the public comment. They may have said, I'll wait until, you know, they actually vote and I'll go then and hang a sign or do whatever they wish to do.
But the point is you have a right to be there for the vote. It's not that there would be much interaction. It sounds like if proper procedure had been followed and then there's a subsequent notice that says in 30 days, we're going to meet again and we'll be voting on it. That wouldn't be a time to be heard, as in you get a chance to walk up to the podium. You could wear your hat or you hold your sign. But no one was given notice.
Or you could lobby you lobby the agency, say, don't vote for it. There's a lot of, public comment is not the only thing you can do. The public has a lot of other opportunities at their disposal to express opposition to a vote if they knew it was taking place. If the mere purpose of this was to accept comment, people might not realize, hey, we got to get to work and convince the members of the election board or, you know, write op-eds or whatever actions they might take.
Mr. Corey's sign on the smokestack.
Absolutely. So, you know, again, this doesn't require a lot, Your Honor, to just give effect to the legislative requirement that the state election board exactly comply with the requirement that it give the public notice of its intended action. It did not do that.
Okay. Any other procedural defects you want me to
Another
hear
very
briefly about?
significant procedural defect. And also reflective of the very rushed other part of subsection A.
So I'm going to interrupt you because we had a good discussion about this at another hearing on similar topics. I thought this law says at some point you do need to provide a concise summary of the views that were expressed, but there's not a deadline for it. And so there's no case law saying you've got 30 days from the passage of the rule. Really, the trigger time was passage of the rule. It's not an infinite period of time. This seems pretty squishy to say it's been violated. Maybe today, technically, it hasn't been complied with because that summary is not yet done. We had been promised that that summary was about to come in other case. Isn't that true here too?
It is true.
Okay.
They also did not issue a statement of reasons or address the public comments. But I think that the two defects that I'm talking about here are.
Oh, this is different. What you put up on the screen is not, I'm sorry. I'll be quiet. Tell me about this.
Yeah, this is not in our brief because in the rushed way that this whole proceeding has happened, in the rushed way that the state election board adopted this rule, we actually very recently discovered this problem, which is very significant.
Okay.
So the subsection A of the AP 50-13-4 also requires exact compliance with the synopsis requirement. This is what the notice looks like that goes to the public of rulemaking. And it contains a 3-part requirement of the synopsis. And of course, the synopsis is for the hand count rule is behind tab 2 of your binder. This is exhibit 2, notice of proposal. The second requirement is a description of the main features of the proposed rule. And then the final third requirement is in the case of a proposed amendatory rule, the synopsis shall also contain the differences between the existing rule and the proposed rule. So let's look at
And most of these were amendatory. I don't know if I've ever used that word before. Were there a couple that were whole cloth new rules?
I
Or
believe,
they all were amendatory?
I believe they were all amended rule concern on the hand count rule.
Okay, it clearly was an amendment.
Yes, Your Honor. It was clearly an amendment as reflected in Exhibit 2. So this is the synopsis for the hand count rule. As you can see, it's titled Synopsis of the Proposed Rule of the State Election Board. Per element 1 of the APA, the first paragraph describes the purpose of the rule. We don't challenge that. The second paragraph describes the main features of the rule. We don't challenge that. The third and most important section describes, quote, the differences between the existing rule and the proposed amendments. And this is where we see this red line that purportedly reflects the changes that would be made by the rule that was under consideration. And you see even that there is a note that underlined text is proposed to be added, telling the public if the text is underlined, it's new. Meaning if it's not underlined, it's not new. Now, did the SEB get it right? The answer is no. There are significant differences between the amendment, the new rule, and the old rule that were not reflected in the red line set forth in the notice. I've counted actually 13 missing references. They failed to include any strike-through language, language that was removed from the original rule, not reflected in the notice. All of the red on the right side of this screen are differences between the old rule and the new rule that were not reflected in the statement of differences in the synopsis.
Is there a case law that says, oops, you know what, they need to get it close, but this was a typo, or
No.
this looks like a little bit more than a typo, but maybe they meant to put the word scanner in front of ballot box, and that was a technical omission?
There is not. And any such case law would probably be overruled by the Supreme Court because this is an exact compliance requirement. And again, subsection D distinguishes between what the state agency must exactly comply with and what it can substantially comply with. And you can't, sort of get the red line half right.
So that I understand this slide 28 on the screen, the box to the left that says P2, that is what's in the synopsis. If I were to look at the synopsis, which is Plaintiff's Exhibit 2, the underlining would be what the board told the public. This is what we're adding. This is part of the amendment. Everything that's underlined will be in the new version of the rule. So the box on the right, stuff that's red, if it's struck out, was supposed to be in there. In other words, they said the new rule will contain the phrase. No. Okay.
The stuff that's stricken was in the old rule, but deleted from the new rule. So in other words, if you look at,
That's not in the new, if I read the new rule now, it's not there.
that is language removed by the amendment that is not reflected in the differences.
Okay, got it. So if I were to look at the synopsis, it doesn't tell me that the new rule will get rid of that phrase and
Correct.
place the paper, but the new rule actually did do that.
Correct. It just failed to include any strike-throughs at all.
Okay,
For whatever reason, performed as a part of this notice just didn't capture any deletions at all.
okay. All right.
Including deletion and replacement of, in the bottom part of this, of the date and time that the ballot box was emptied, which exists in the original rule, and the replacement of that with hand count ballot total as certified by the 3 poll officials. If you look at the actual notice, you can see the language, hand count ballot total as certified by the 3 poll officials is not underlined as new language, even though that is new language.
Okay,
So they failed to even correctly reference what was being added. Any member of the public reading this notice would have a completely inaccurate understanding, an incomplete understanding, potentially have been misled by this rule. And that's actually important because if you read this notice, and this is what I did. I read this notice and I said, oh, really? The original rule had a reference to hand count ballot total as certified by the 3 poll officials. Because if that's true, we might not have a good case if that happened many years ago or many months ago or whatever. It turns out that's just new language that they failed to underline. And so it does not accurately reflect the differences. And if Your Honor would like, I mean, don't take our word for it. This is from the Secretary of State's website. This is the current version of the rule before any amendment would take effect on October 22nd, and the court can perform its own analysis to ensure that we did it correctly. We
Forward to that.
had quite a number of people look at this, though, to make sure we were right because of how important
Well, I mean,
it is.
From one perspective, you could be half right. If only half of what's read is properly read, meaning the color red, then it wasn't an exact synopsis indicating what the differences would be.
I don't think I understand that.
It's okay.
Okay.
I appreciate the work that was done to highlight the number of omissions in the synopsis of differences in the amendatory language.
That's right. I mean, you can see just, the word scanner ballot box in the second sentence, that scanner word is not underlined, but that's new from the old rule to the new rule.
I got it.
And I count 13 edits that were not included in the red line.
Okay.
So, Your Honor, given the board's failure to not only tell the public that it would be voting on this rule, but its failure to even accurately reflect the differences as required by the APA, to which exact compliance is legislatively required, this rule need not even reach the question of the state election board's authority because it simply utterly failed to comply with the APA and its haste to adopt this rule. Now, as I said earlier, and this will be my final point, Your Honor, we've moved for an injunction, we've moved for a temporary restraining order because of where we stand. When the rule takes effect, we will be 2 weeks before an election. We stand here today 3 weeks before an election. As the Secretary of State has said, it is simply too late, far too late, in his words, for counties to implement new rules and procedures when many poll workers have already completed the required training. The Secretary of State noted that the hand count rule was the most concerning because of the tremendous personnel resources and time that would be required to comply with it, the significant delays in reporting that could result, and that it would disrupt existing chain of custody protocols, needlessly introduce the risk of error, lost ballots, or even fraud. These were all comments by the chief ultimately deciding not to even train any of our 2,000 poll workers on this rule due to their view that the rules was invalid. This concern has been substantiated by the workers in our the election administration within Cobb County. We've introduced the testimony of Chairwoman Silas, and I'll go through this somewhat quickly because I've already referenced it on a few occasions. But in Cobb County, application of this rule would involve at least 444 poll workers because we have 148 precincts. And so we would have to train at least 444 poll workers on the hand count rule when we have no training materials, we have no support from the Secretary of State. And keep in mind that that training isn't just about how to count, but also how a poll manager might decide how to address any inconsistencies or how they might decide whether to count the night of the election when poll workers have been working from 7 in the morning or often 6 in the morning through the close of the polls, a 15-hour day. Ms. Silas notes that this kind of hand counting could also delay the reporting of the results, since we would be taking resources from one area, putting it to another. We will have to incur additional costs that we did not budget for in our annual budgeting that took place, last year. And certainly we have the concern that our poll workers may not be, may just be exhausted after a very long workday, and counting in those circumstances on election night after you've worked for 15 hours is just not the best way to do it. It introduces the risk of error. It's more likely that a count would go much longer than we estimated because of the exhaustion of our poll workers and the fact that some of them aren't going to have at all been trained. Some of them will have only, could not be as experienced as the ones who did our sample. We've also received mail from members of the public that have gotten misinformation, as the court addressed earlier. People have warned, representatives of our office, poll workers, that they better comply with this hand count rule. We'll be watching. The intimidation has already begun and is only going to continue. This is going to require security. There's also.
But that pressure would exist if this rule had been passed 6 months ago and there were operating instructions in place. People get energized about elections and say things that are intimidating. I don't mean to minimize this concern at all, but I don't put that at the feet of the state election board or even the timing of the rule. Had this been passed at a more reasonable juncture, maybe with more care put into it so that we didn't have all these discrepancies in the synopsis of differences. And so the Secretary of State could have pushed out training, et cetera. There's still going to be people who say, I'm going to pull up with my pickup truck with the flags on it, and I'm going to make sure you hand count correctly. And if you don't, there's going to be trouble. I don't think it's fair to put that at the feet of the rule or the state election board. That goes at the feet of polarization in our community.
I understand, Your Honor, and totally agree. We're not blaming the state election board for any acts of intimidation. What we're saying is that because we have so little time to prepare, that we are suffering irreparable harm because we have uncertainty about what we have to do. And if this rule is going to come into account, we're going to have to pay more security officers. We're going to have to make decisions about where the countings will take place, how to provide public access, which is required by the rule, what security measures need to be taken in light of the polarization.
Okay.
And so because of the polarization,
it amplifies and magnifies the cost.
Right, and it suggests that a reasonable rule would have, like this, would have been implemented far more in advance of the election than 2 weeks, so that we can deal with the added risks and concerns that our current political environment creates.
Okay.
Obviously, the rushed nature of this also could create questions, and voter confidence and lead to disinformation and distrust, as the court has already noted. And so all of these issues constitute the irreparable harm that we as a superintendent, we as an election board are suffering and will suffer, implemented or takes effect in 1 week. And for that reason, Your Honor, we request that the court enter a TRO or an interlocutory injunction. The court would be, of course, well within its power to do so today, while considering the broader issue of a declaratory judgment with respect to the validity of the hand count rule and frankly all 6 rules. And we ask that it do so that our poll workers, our elections director can focus their resources on training for this election without having the concern that they might have to really change all their plans and suddenly try to train and add resources and staff and try to address this hand count requirement.
All right, thank you.
Thank you.
So I need to give our court reporter a break in a moment, and probably everyone else. We're approaching noon. I've got a little more time than I thought, so we're certainly going to hear from both sides. But I'd like to get a sense if there's much more from plaintiff's side. I know you had said Mr. Suss was going to cover some things, and yet you talked about them as well in some ways. And certainly we have interveners. A lot of what they've had to say that I've processed is consistent with, but I don't want to keep anyone silent. Mr. Suss, give me a summary of what you were going to cover, not substantively, but I was going to talk about A, B, and B.
Sure, Your Honor. So I'm just going to be talking about the sort of cross-cutting arguments that apply to all 6 rules, not just the hand count rule. So the notice deficiency would be one of those issues. In addition, the question of whether all 6 of the rules are consistent with the SEB's rulemaking authority, which is limited to rules that are fair, orderly, and promote uniformity in elections. Also, whether each rule is reasonable under the APA. And that sounds like a lot of issues, but there's a lot of overlap between those issues.
Sure, and I think we've covered notice pretty thoroughly, so I wouldn't think there'd be a lot to add.
No.
Okay.
Rules, including the poll watcher rule and the daily reporting rule, which are 2 rules that were addressed in the Attorney General's memo.
Okay, thank you. And for our interveners on plaintiff's side, Mr. Varghese?
We intend to be very brief, Your Honor. Supplement. We intend to be very.
I know I heard that part, and you're being brief in talking about what?
We want to supplement evidence of additional irreparable harm that's been offered by the BRE petitioners and other exact compliance citations that if Mr. Suss doesn't cover, we can provide to the court.
Okay.
We want to move Cobb's T on the red motion.
Are your exhibits something Mr. Thomas has seen
He has, Your Honor.
before this morning?
Correct. He
Okay.
received them Sunday at noon, and I'll let SEB speak for itself, but I believe they're going to stipulate to the admissibility.
Got it. Okay. Why don't we do this? Let's take a quick break. And during the break, think about compression. And I'll hear from the rest. Pivot and Mr. Thomas, you and everyone else, and Mr. Kaufman wrote a response. Much of what I have not forgotten anything you've already said, anything, but we don't need to talk about capacity to sue. But it was very helpful to hear what you had to say about why. Like the easy answer isn't, let's just take a timeout to go into effect, but maybe they go into effect January 1 rather than October 22. And so you won't need to repeat that, walking me back from that notion, but you'll be able to cover everything else you need to, you want to. Okay. All right. Let's be back according to that clock at 12:05, please.
You need anything? Like a water?
You'll move them up. Good. Okay. Will they let you know? Because I'd love for Michelle to call this woman back to say he's gone. Okay. I mean, you think it's today? It's this week? Okay, so it might not be till, and they don't need to do something crazy, like just get him out now. Yeah. So he'll be on whatever bus goes next. He'll be on. Okay.
Okay. It is, but they.
Because those are still.
You doing all right?
So as I understand it, you scan.
Did they book you for all day or do you have to leave at a certain, we're not gonna go super late, but we're just gonna probably go a little later than we were.
The ranks, exactly. That's, yeah. They're aware.
You're a realist. All right.
The rule doesn't address any. The mic's- Good.
So sorry.
Are you staying here? It says. But I think.
This- Oh my God. Yeah.
What kind of order? Main City.
Or you could say. Sure. Right.
You ready?
Yes, Your Honor.
I wasn't asking you, sorry.
Oh, sorry.
Court reporter. Just asking the important person. You were
Understood.
standing up there, so it was kind of obvious you were ready. Okay, let's get back on the record in Cobb County Board of Elections and Registration versus the State Election Board. We're going to hear a little bit more from some of the spokespersons for peoples whose interests are aligned with plaintiffs, and then we will pivot to Mr. Thomas and the defendant. Mr. Suss.
This, but I did want to emphasize that the argument with respect to the deficient notice and the notice of proposed rulemaking applies to all 6 rules.
Let me ask about that. So all 6 were adopted at the same time?
Correct, Your Honor.
So the notice that says all we're going to do is receive comment and discuss would be for all 6. And yet
Correct.
all 6 on that date, September, whatever it was, were adopted. It wasn't just comment on, it was comment on, thanks, nice to hear from you. Now we pass all 6.
That's correct, Your Honor.
There were other arguments about the deficiency of the notice. I guess it was the synopsis that accompanied. As for the hand count rule, are there similar issues with any of the other 5 rules?
There are not.
Okay, so the notice deficiency for the other 5 is solely, you said on date X, we're doing Y, but you did Y and Z. And Z was pretty darn substantive, and that's a notice deficiency.
That's correct, Your Honor.
Okay.
And just to sort of give some additional context here, there was, since this summer, the SEB has proposed a flurry of new rules, and that even those who closely track Georgia election law had trouble keeping up with. At the September meeting alone, the board was considering 11 proposed rules. So members of the public
When you
rightly-
say considering, they were discussing, or was there also a notice that said, these 6, all we're going to do is talk about them, but these 5, it's vote day?
So for all 6, all notices of proposed rulemaking for all 6 rules had the same boilerplate language, and it said that they would vote to, or sorry, my mistake, that they would hear public comment on the
Right.
rules.
But it's telling if there were also notices issued that said on September 20, what was the date? September 20th?
September 20th.
September 20th, we're going to actually vote on these other rules. That would show that they knew the difference between voting and discussing. Were there proposals for which the notice said, today we vote?
No, Your Honor.
Everything was discuss.
That's correct, Your Honor. For all 11 proposed
Right.
rules that were, that public comment was heard on September 20th, it had the same boilerplate language with respect to the board hearing public comment on the rules, and none of the notices said that they would vote to adopt rules.
Have you ever seen a notice from this state election board, this composition of 5, that said, here's notice, today we will consider whether to adopt?
So, Your Honor, I have not seen that from the state election board, but I have seen it from other agencies in the state who clearly do know how to say that they are going to vote to adopt a rule at a particular meeting. And we cite at least one of those examples in our TRO motion. So it is clearly possible to do this, and other agencies know how to do this. But to answer your question, no, we do not have an example of the SEB specifically doing that.
Okay.
So, Your Honor, other than to note that procedural deficiency applies to all the rules, just next move on to the second point, which is that all 6 rules are also invalid because their last-minute timing is not conducive to fair, orderly, and uniform election administration. And this is sort of one possible hook for importing a sort of Purcell principle in this context. The SEB only has statutory authority to adopt rules that will promote uniformity in election administration and that are conducive to fair, legal, and orderly elections. Adopting election rules that would go into effect on October 22nd after early voting has started and just 2 weeks from election day is not orderly, it's not fair, and it won't lead to uniformity. It will do the opposite. Both the Attorney General and the Secretary of State made that exact point to the SED before it adopted these rules. And they correctly cited the US Supreme Court's decision in Purcell, not because Purcell binds state courts, but because it's just common sense. Changing the rules this close to an election is unfair to election officials and the workers who will be blamed for any disruptions. It's disorderly, and it will promote non-uniformity across the state's 159 counties, especially since the Secretary of State has said that he is not providing any statewide guidance on any of these rules pending litigation. As the 11th Circuit recently held in a case applying Purcell, changing election rules at the last minute generates election administrator confusion, and it undermines the state's interest in running an orderly, efficient election. And notably, that case applied Purcell to an action taken more than 3 months away from a municipal election. Purcell itself involved a Court of Appeals order that was issued a month away from an election. And yet here, these rules are 14 days away, will take effect 14 days away from the election. So if there is a Purcell window, we are in the red zone right now. And in the words of the Secretary of State, changing the rules this late in the game is, quote, absurd. Because the SEB's last minute rule changes will cause disorder, unfairness, and non-uniformity, they exceed the SEB's rulemaking authority. And under the APA, any rule that exceeds the scope of or is inconsistent with statutory rulemaking authority is invalid.
When you say exceed seems like the wrong verb. I understand the requirement is that there be a statutory basis, that the rules have to be authorized. We're going to talk about it a little bit, but you were focused on reasonableness. And there's no authority to issue a rule that's unreasonable. That would hit that tripwire. But it sounds like the main concern you're articulating is not so much the substance of the rules being unreasonable. Every poll worker has to do 100 push-ups before starting the day. It's the timing makes it unreasonable, sort of situational unreasonableness. So again, my example, if these had been adopted with notice in February of 2024, so that the Secretary of State would have had time, so Cobb County would have had time, because they don't train their poll workers a week before, but they train them months before, and this could have been baked into the training.
That's exactly right, Your Honor. I mean, rules that would otherwise be unobjectionable become objectionable when you adopt them so close to the election. And so that sort of principle applies to all of the rules. And Your Honor focused on exceeding the scope. I would also highlight the inconsistent with. That language is also important here because the statute requires that the rules be, that the board's rules promote a fair and orderly election administration. So relatedly, this is sort of another potential hook for the Purcell-like argument, is that the rules are unreasonable due to their belated timing. The Court of Appeals has held that the test of a rule's reasonableness in the industry it regulates, and the court has further explained that a reasonableness analysis must consider the degree to which the rule advances the purposes of its enabling legislation. Here, the rulemaking record, the notice and comment record, was
Is there a specific case you had in mind when you were saying that?
Yes, Your Honor. It's Georgia Oilman Association versus Department of Revenue, and the site is 261 Georgia Appellate Court 393.
Okay.
And so here, Your Honor, the rulemaking record was replete with evidence of the immense burdens, disorder, and confusion to election officials and workers that would result from these new rules and adopting them so close to the election.
What's your response to Mr. Thomas? He would take issue, I don't mean to speak for him, with that adjective immense. Certainly a rule imposes burdens. Now you have to count these boom of, we're going to be here until 1 minute before that week plus a few days deadline to even certify. Counting these things is going to be endless, Herculean task. 14 minutes, 22 minutes. What's the immensity, or do you want to use a different adjective than immense? It's a burden, but.
Well, the immensity is not just the hand counting, it is preparing for the hand counting. It is training for the hand counting. It is staffing. This report, the Silas affidavit, I'm sort of straying outside of what I said I would talk about, but the Silas, right. The Silas affidavit lays out how the rule and preparing for the rule concretely impacts the Cobb County Board and the preparations for the election. So even if theoretically under perfectly controlled conditions, hand counting might take a certain amount of time, you have to factor into place both rush into place with inadequate opportunity for training and inadequate guidance, or a total lack of guidance, rather, from the state's chief election official.
Okay.
And so this reasonableness prong, Your Honor, is simply another sort of hook for that argument. Those are all of our global challenges, and I'd just like to briefly address two specific rules, the poll watcher rule and the daily reporting rule. So the poll watcher rule is based on Georgia Code Section 212408C. That statute identifies 3 areas in tabulating centers where poll watchers shall be permitted. It says the check-in area, the computer room, and the duplication area. The statute otherwise gives county superintendents discretion to grant poll watcher access to such other areas as the superintendent may deem necessary. Now, the prior poll watcher rule just tracked that statutory language pretty much verbatim. But what the new rule does is it inserts new text in the middle of the clause that gives the superintendent discretion, and you can see it up here on the screen, Your Honor. The highlighted language is covers the area where it gives the superintendent discretion in the last clause and such other areas. And then we have all this new text that's inserted before the phrase "as the superintendent may deem necessary." And so the Attorney General's office opined that the rule goes beyond the statutorily designated list of placestead, supplants the superintendent's discretion with the SEB's own, and the Attorney General concluded that the rule, if adopted, would very likely be subject to legal challenge as invalid. Now, our position is that there's actually two ways to read this rule. One is sort of in line with the Attorney General's interpretation, that it expands the designated areas where poll watchers must be allowed in tabulating centers. If the court accepts that reading, then the rule does conflict with the election code and it should be declared invalid. But another way to read it is that it simply specifies additional areas that the superintendent may allow poll watchers. And if that is the reading that is accepted, then the rule doesn't really do anything. It's more advisory than actually binding.
All these things you could do, you can still do. We just gave you some other ideas to think about as you're pondering where would you let people be.
That's exactly right. And we would submit that that's probably the better reading of the rule. But importantly, Your Honor, if the court reads the rules effectively doing nothing, it should provide declaratory relief to that effect, because otherwise there's going to be uncertainty and insecurity with respect to the meaning of this rule. And there could be confusion on election day about where poll watchers are permitted, and that could lead to disorder and security concerns. In addition, the mere existence of the Attorney General's memorandum also creates uncertainty and insecurity with respect to petitioners' legal duties potentially under the election code versus the SEB's rules. And finally, Your Honor, just briefly on the daily reporting rule. So this rule does impose new obligations, but they are not a major departure from the statutory obligations. So the Cobb County Board is not opposed in principle to this rule. But again, the issue is that the Attorney General has specifically opined that this rule is likely invalid because it, quote, seeks to go beyond the statute to require, among other expansions, additional information regarding the substance of the ballots, i.e. the number of political party or nonpartisan ballots cast. So given the Attorney General's opinion, we need to know whether the rule is valid or not in order to carry out the election.
My read was that this was a whole new rule. I had asked Mr. Kaplan, was everything a mandatory, or was there one? I couldn't remember which one from my prep for today. Is not the daily report, that's brand new, whole cloth. There was no 0.21.
That's correct. This is the only new rule of the six.
That doesn't change anything, I mean, other than that you couldn't run afoul of having a bad synopsis of what the differences are, because the whole thing is new.
That's right.
Okay. So to distill your argument, one, it would be invalid because the General Assembly already said, here's what you have to report. Sort of like me saying you have to do these 4 things. And this rule says, well, now you have to do number 5. And the General Assembly knows how to add things if it wants to, knows how to add the power to sue if you're going to sue. And it didn't include this. And the state board doesn't have the authority to expand the legislation by adding this additional reporting requirement.
So, Your Honor, just
or am I missing it?
Well, just to be clear, the Cobb County Board's position with respect to this rule is that it's procedurally invalid, and it is invalid because it's outside of the scope or inconsistent with the board's rulemaking authority due to the late timing. We do not take a position on the statutory authorization issue offered by the Attorney General.
Okay.
And so but that does create legal uncertainty for the board, and so we leave it to Your Honor to resolve that. However, other than the procedural and timing challenges that we raise, we do not raise a specific substantive challenge to the authorization for this rule.
Okay.
And so for all those reasons, Your Honor, we respectfully request that the court declare all 6 SEB rules invalid and permanently enjoin their enforcement.
Thank you, sir. You were succinct. The bar's been set. Who's next?
I think from the Cobb Election Board, Your Honor, that's all we
Oh,
have.
I thought that would, I mean, I will circle back when, as the plaintiff, if you've got concluding remarks, we'll pivot back to you after we hear from the defendants. But I'm ready for whoever wants to say something on behalf of the plaintiff interveners. You want to stand up yet again?
Good morning, Your Honor, or afternoon. I will try to match Mr. Suss's succinctness, and I'm sure that the court will tell me to move along if I'm failing to do so. So just a few points that I want to make. First, as an initial matter, we want to move to admit certain exhibits. And these are exhibits. Some of our exhibits are also on Cobb's list. These are the exhibits that are not overlapping, and that's intervener petitioners 5, 6, 9, 10, 11, 12, 15, 17, 20, 21, 22, and 23.
Mr. Thomas, any objection to, I know you've objected to intervention just on a timing basis, but here's the result. He's talking now. Any objection to these exhibits coming in as part of the record?
No.
Thank you. They're in.
Thank you, Your Honor.
And Ms. Niles has them already. I guess you said that because that's how you also got them to Mr. Thomas and his team.
We got them to Mr. Thomas before we sent them to Ms. Niles, but she has them as well.
Okay.
In part of an effort to be succinct, we filed a petition. We've also filed an emergency motion for preliminary injunctions. Our arguments more fully fleshed out there. We're also adopting Cobb's motion for TRO as well. A couple of initial points. The capacity to sue argument does not apply to the intervener petitioners. And so this case can move forward regardless of how the court decides that decision. I really want to just focus primarily on the conflict and the irreparable harm that's going to happen if this rule goes into effect. And so Cobb has spoken very well for their interests, but this interest is statewide, as evidenced by the statements of the Secretary of State, as evidenced by the statements of Gavrio, the Georgia Association of Voter Registration Election Officials, and as evidenced by the BRE petitioners that I represent. And all of them are concerned about the impact of this rule. It would be one thing in an ideal, sterile environment to have 3 people who are fresh and energized sit down and count ballots. And I think that's what Cobb attempted to do, and they got a certain number. But as Mr. Kaplan recognized, that's not how this is going to play out in reality. As our petitioner affidavits reference, poll workers get to their polls as early as 5 a.m., 5:30, 6 a.m. They stay as late as 8 p.m., 10 p.m. And so we're talking about adding something on top of an already 14 to 16-hour day when people are exhausted.
Unless you decide to do it the next day.
Unless you decide to do it the next day, but then there are challenges that come with that as well, Your Honor. So you've got the poll workers who typically sign on to work one day at a poll location, maybe near their house, maybe not, now being asked to come to a county office, which in Fulton could be, an hour from Johns Creek without traffic. And so they've got to be there the next day. The county has to figure out how they're going to implement the count the next day because the count has to be observable by the public. And so in Fulton, for example, 481 precincts, there's no way that Fulton County in its main office and its tabulation center is going to be able to facilitate a simultaneous count. So it most likely happens in phases, right? And so, and at the same time, I think it's important to recognize the BRE isn't sitting around waiting to get to Tuesday this year and vote to certify. They have a number of other tasks that they're performing at this exact same time.
Do you agree that the tasks that the board needs to perform is not delayed by the hand counting rule? Because that which is being withheld from the board isn't something that the board has an immediate response. They're not counting ballots anyway. In other words, we use the wrong terms, but the memory cards, whatever the board, the superintendent would be doing to accomplish certification can start that very next morning or even that evening because the necessary material is being provided to the superintendent.
So I want to make a couple of points on that. First, on the memory cards, it is.
Well, do you agree or disagree that this hand count, should it occur, should it take time, should it be cumbersome, will be a resource drain, no question, but it doesn't directly interfere with the certification work that's supposed to be going on because that which is being withheld isn't part of what I'll call the certification flow.
And what I want to describe is instances in which it may.
Okay.
Right. So first off, with the memory cards, most precincts in the state transmit everything together, and that's what quite frankly, the statutory scheme contemplates.
That's what people have been trained to do.
Exactly. And you have to account. I mean, when it's not just somebody gets up and says, okay, I'm going to drive this memory card down, right? There usually happens in pairs. There's often law enforcement along with them. And so, maybe if there was all the time in the world, we could plan to do that and make sure that the memory cards all get to the tabulation centers in all these counties in enough time to get that 11:59 p.m. deadline, right? So that's just one point.
But why is it any different I didn't fully understand the flow of information from precinct to superintendent and was based on what I understood from Mr. Thomas, the misimpression or mistaken impression that until they're done hand counting those ballots, nothing goes anywhere. And so if I'm the superintendent, like, come on, I got work I need to do. I've got the midnight deadline for the unofficial count, and I've got certification. I can't do anything because you guys are 50, there's another 50, and the next person is counting the 50. But what I understood Mr. Thomas to say is divorce those two because the ballots are staying behind the paper and we'll count them, and whatever this mystery control document that doesn't exist, and I think only the Secretary of State can issue, and he's not, that's what would be sent on to say, hey, there was a little hiccup in precinct number 17. We counted 190 paper and the machine said 191. That can all happen without interfering with the transmission of everything that ought to be going to the superintendent so that corporate body can begin certifying. Correct or incorrect?
It ought, if there was appropriate planning where counties could prepare and make plans so that they could submit the memory cards separately from finishing up the hand count, right? Then
if they had enough people, because they've already planned to deliver everything to the superintendent or the tabulating center. That's a plan. It has to happen.
Yes.
And all that would change is don't send the ballots. Send everything else but the ballots under this new system.
Correct.
But that would mean then 2 trips down to the tabulating center because ultimately the ballots have to get there. And setting aside all the strange, what's the security? These ballots are just sort of floating around, and who's been deputized, and they haven't been deputized to even be touching those things. Set that aside. Is it not true that the certification process could move forward unabated while the poor poll workers stayed late or counted them the next day?
It's unclear to me under the rule because the rule gives authority, taking it away from the superintendent and giving it to a precinct poll manager to investigate and correct discrepancies, right? And so how that fits into what is the appropriate vote count to certify, I don't know the answer to that question. We don't have guidance on that.
Okay, which is part of the problem.
Which is part of the problem, Your Honor. Just want to highlight one other conflict, and I just touched on it, is 493B. The legislature gave superintendents the ability to investigate and correct discrepancies. And also, and now this rule attempts to give it to poll managers.
Same discrepancy, or, 493B describes a specific scenario where a discrepancy could arise, which is not the kind of discrepancy that the hand count rule contemplates.
Correct. So I think the legislature has determined the scenario in which, in the specific type of discrepancy, it wants investigated and who it wants to investigate that. And so that's not authority they intended to give to a poll manager. The other statutory provision is not so much a conflict, but it is the legislature speaking as to when it wants these paper ballots actually reviewed and analyzed. And that is in the context of a risk limiting audit post-certification. So the legislature has specifically laid out, this is when we pull samples of these paper ballots. This is when we count them. This is the process to make sure that the electronic count we got matches the paper count we got. And so it's not, and the SEB is trying to expand that. It's not contemplated by the code. I'm going to be brief on a few of these things.
Where is that place?
The
What's
risk limiting
statute?
audit, I'll have to get it for you. I don't
Okay.
have it off the top of my head, but I'll have it to you before I leave today.
Okay.
Each of our BRE petitioners echo the testimony of Cobb, the Secretary of State, and Gavrio. They're concerned about how this process is going to play out at the end of a long election day. They are already being told by poll managers, we are not doing this job if we have to hand count at the end of what is already an exhausting day. So
Meaning I'm the poll worker and I'm saying, I'm not showing up at all. If you tell me there's a chance that I'm counting by 50s, these ballots, I'm taking this year out.
yeah, and that's in the affidavit
Oh,
specifically.
no, I read it. I just wasn't sure what you meant by what you said, but that is in the affidavit.
Thank you, Your Honor. Also concerned about the training piece, which is again covered, but all of our BRE petitioners concur. And in the Secretary of State's letter, September 16th, I believe, that's already in the record, the Secretary acknowledges that most training has been completed. Right. I mean, before the rule is even passed. And so I know the court earlier had a question about, well, it was passed weeks ago and not 2 weeks. But the point is, and all of our petitioners affirm this, the training or the preparation for the elections begins at least a year in advance. Training begins weeks to months in advance. And trying to implement this rule at this last minute is simply not sustainable and would cause irreparable harm to our clients. We've also discussed, and I won't dwell on this, in our papers, the diversion of financial resources, concern about error, fraud, and spoliation of ballots for this manual handling. That's concerns shared by the Secretary of State.
When you say ballot, I want to make sure I'm as informed as I can be. The actual piece of paper that people are handling, Mr. Thomas has said it's a receipt. A concern that's been raised by plaintiffs is, well, what if in counting, I tore that one accidentally and it tears it in just the wrong spot so that if it's a QR code, that's torn in half, or if it was a number that you can't figure out what that receipt ever stood for because of what happened, or someone just brushed against it and all 50 fall on the ground into spilled coffee. What is being lost? It's not a piece of paper that says McBurney voted for Varghese. It doesn't have that, but what is it and what could we not recreate other than to say, well, I can still, they're soggy and they're brown, but I can count them and they're 50 right there.
Maybe you could count them if they're soggy and brown. You can't count them if they're lost or misplaced, which in this type of exercise is certainly a possibility. And I'll point the court to the July 9th transcript of the 11 at pages 224 to 225 and pages 137. It discusses a pilot project where there was a pilot project to see whether this hand counting can occur. And they eventually gave up on the pilot project because everyone couldn't come to the same numbers. Because in reality, when you take 3 people, particularly at the end of a long day, and you're trying to do this, 14 minutes, maybe if everybody gets to the same number once, right? That assumes 2020 or 2022 are good years to use, and they're not, for the reasons I already stated.
Sure. But what is on the piece of paper?
The
Not
piece,
what it was just handed to you. That could be a private note.
I
Sorry.
can't read that.
That's not what I meant. But the receipt, the thing that people are counting, what is on it?
What is on it is a QR code and the vote selections that you made. So the,
Embedded in the QR code, or it would say, it might not have my name, but it would say, voted for this candidate in this race, voted for that candidate in that race.
so both embedded in the QR code and also listed out.
Okay.
And the reason it is listed out, two reasons. One, so the voter can get a piece of paper and says, okay, these are my votes, right? We're talking about an 8.5 by 11 piece of paper. And also in the mechanism that the legislature has provided to audit the electronic voting, that piece of paper exists. So you can go back and check the machine count against what's on the piece of paper. Because we as humans, not yet, can't read QR codes, right? So the voter can't look at the QR code and say, I know when I feed this QR code, that's what's going to come up, right? But the piece of paper tells it. That's the way the system works, or reflects it, right? But if we ever have to go back and check, and the legislature has created a mechanism to do that, we go back in a risk limiting audit, and that provision, Your Honor, is OCGA 212498.
Got it. So if one of these ballots was lost inadvertently or intentionally, I'm seeing too many with that McBurney name, I'm going to put one in my pocket and it won't get counted. Lost would be the paper proof of that vote. Sure, there's a microchip that has on it that we had 200 people who voted for McBurney. But now if we counted the pieces of paper that were pro McBurney, there'd only be 199 because one of them was folded, spindled, and mutilated and can't be used anymore. Is that a fair statement?
That's a fair statement.
That's how sensitive these pieces, they're not just a receipt, but if one goes missing, then the physical proof, not the digital proof that some people don't trust, is now gone.
Correct. And it seriously compromises the ability to conduct the paper copies against the electronic records and make
Okay.
sure everything matches up. I believe petitioners have some arguments they may raise with regards to standing and justiciability. I can get into that, but I think it's all covered by the court's order this morning. Questions for me? I have nothing further, but my colleague, Mr. Kastorf, is going to briefly provide some additional citations to the court on the APA question.
You guys didn't tell me there was going to be another speaker. All right, Mr. Kastorf. Good afternoon, sir.
Good afternoon, Your Honor, and I think I can win the award for brief this presentation. I wanted to address specifically APA procedural compliance. I'm not going to repeat anything that Mr. Kaplan already said, but I thought there's some other resources that may be useful to the court. First is that our exhibits, exhibit number 22 and 23, are examples of proposed rules issued by other state agencies. As Mr. Suss points out, we unfortunately couldn't find any examples of the State Election Board getting it right, but we put two examples in the record of other agencies, and it shows how simple it is to engage in exact compliance. They each state the department will consider the proposed new rule for adoption at X time at X date. It's simple. The other reason why I think Exhibit 22 may be helpful to the court is it is a great example of how you deal with proposed amendments. The way the Department of Banking and Finance handled it was by describing each of the changes, whether they were additions of subtractions, in plain language so that the public could understand, which is a much better system than an inaccurate. Second, the court had asked about whether there is, correctly pointed out, there's only one case talking about it specifically in the context of the Administrative Procedure Act. However, exact compliance and similar concepts do exist in other areas of law. One is that exact compliance is required for accord and satisfaction. An example is Parker v. Pender, 174 Georgia 579. And in that context, exact compliance means exact compliance. Second, Georgia law also uses a similar but actually laxer standard of strict compliance, such as in anti-litem notices. And there are numerous Court of Appeals cases that say, quote, strict compliance is exactly what it sounds like, strict. An example is DeFloria v. Walker, 317, Georgia App 578. Now, strict compliance is already strict, but exact compliance is even stricter than strict. The plain language of exact is more stringent, but this court doesn't need to just rely on common sense and plain language definition because Georgia courts have said as much. For example, in State v. Fielding, 229 Georgia App 675, the Court of Appeals held that when a police officer reads an implied consent notice, he must read it exactly as written with no deviation. And there the court specifically explained that even strict compliance is insufficient. Compliance must be exact, indicating that exact is stricter than strict. In that case, the Court of Appeals also explained that when the legislature requires exact compliance, it is, quote, obviously intending to provide a bright line test and to alleviate the need for a case-by-case determination as to what notice is legally sufficient. It is designed to make this court's job easy. If it doesn't match, you strike it. And finally, the Supreme Court in Blackburn v. Lee, 137 Georgia 265, 1911, has contrasted substantial compliance with, quote, literally exact compliance, again indicating that exact compliance is something stricter than strict. The final point I wanted to make about the notices is that Mr. Kaplan did an excellent job of laying out how many differences there are in the red line. I want to point out that at least one of those missing subtractions is quite material. The first missing language that's removed is the paper ballots shall be placed into durable, portable, secure, and sealable containers to be provided for transport. In the current version of the rule, pretty much as soon as you close down the polling place, you immediately get those ballots into a careful sealed box for transport. One of the largest concerns we have about this rule is that as soon as you move the ballots to a table and you start counting them, you instantly introduce chain of custody problems. There's a possibility a ballot gets lost, it gets tampered with, it gets ripped, or a worker who's already been working for 14 hours spills their late night coffee on it. If that happens, that ballot is no longer available in a recount or a risk limiting audit. There are already multiple procedures to reconcile how many voters voted at a precinct. The poll pads, when you check in, check the number of voters. The machines where you produce your ballot, check the number of voters, and the scanner checks the number of voters. And those are already being reconciled on recap forms by the Secretary of State. So the marginal benefit provided by an additional hand count is trivial compared to the potential downside that a ballot would not be available in a recount or a risk limiting audit. And because the notice does not mention that it is removing this language, a member of the public reading that notice might not be aware of one of the potential largest downsides of this rule when they're considering whether to attend the state election board hearing, to provide notice and comment, or to otherwise engage in the process. And that's why, under any definition of exact compliance, that failure to include information is material.
Thank you for that. I want to make sure I follow. Mr. Kaplan had on the screen the version that was in the notice that showed what was being added and subtracted. And then he had that box with red in it. And I'm still working through. I think if it was struck through, that meant that was something that was excluded, that they didn't say was going to be excluded. And if it was just in red, it was added, but the notice didn't say it was going to be added. Regardless of what all the red text meant, what you just described, that durable protective bag, was removed as a result of the amendment?
Yes. So I believe it would be that longer red sentence black. I can't quite read it. Yeah, it's the
I see it, durable, portable, but here's what I want to understand. So that being struck through and read there means that the rule as passed and that will go into effect on October 22 does not include anymore a requirement that things go into the durable, portable, secure bag.
That is correct. Instead of immediately moving it into that batch, they pull it out and hand count it, and then it's not added back in later in the rule. It does reference a separate put in, and the specifications on that box are no longer in the rule.
Okay, but critical to the argument about notice, didn't say that's being removed.
It did not.
If I were to read the notice, like, oh, they're gonna do some hand counting, but we still got that durable bag. It didn't indicate that that would be struck.
That's correct. The only way you could figure it out is by doing the type of red line that Mr. Kaplan has performed.
After the fact.
Correct.
Okay.
Not by the face, anything on the face of the notice.
Okay, thank you.
Thank you.
At long last, Mr. Thomas, or any of your colleagues, let's hear from the State Election Board.
Well, just to address a few points that were made by Mr. Kaplan early on about some of the alleged vagaries here, it is clear that it is only election day ballots. And we know that because the advanced voting section of the election code, of the regulations, provides that on the Friday before election day, the poll managers will go in, remove all of the ballots that are in the machines. They will go through that same process. They will seal the box that's coming from the scanner machine, put them in another container, and then take those to the election office. So we're starting.
What in the rule, the hand count rule says, well, don't also do that on that Friday? Or it says do it only on election day?
These are two, 183.114.02 is the regulation that talks about taking the advanced votes.
Okay, completely different space in the set of
Completely
rules.
different, yes.
Okay.
And so on Friday, the scanner machines are emptied. So you start election day with empty scanner machines. That's not vague. That's not unclear. That's how it works. There's been a lot of reference to this notion of the poll manager having this authority and therefore, intruding upon the superintendent's authority. And how can we understand, what the language of this means? But you sort of pointed to that in that first, you've got to address the context in which that language is being used and also address the task that they are actually engaged in. And in that task, the only thing that they're supposed to do is count the votes, count the ballots, and make sure the number of paper receipts in effect matches what's on the tabulation tape. That's it. So to the extent that they're supposed to, if there's an inconsistency, fix it, it's limited to seeing if they can, is there a spoiled ballot? Is there a ballot that's stuck in the machine? Once that ballot box once those paper ballots are removed from the machine, you can't do that anymore. That's it. That's the best time to make sure that you can collect all ballots, including emergency ballots, spoiled ballots, and any ballots stuck in a scanner or otherwise. And that has happened, and that's in the record. Second, that same language already exists in
What same language?
the discretion, in effect, that people have complained about in 183.112.12A2. And this is with respect to filling out the recap form against the tabulation tape numbers. And it says, if the numbers recorded on the recap form do not reconcile with each other, the poll manager shall immediately determine the reason for the inconsistency, correct the inconsistency if possible, and fully document the inconsistency.
It's the same language.
And it's in the context of the same thing. Do the numbers on this form match the number of voters that we've had check in? There's been no problem with that language, and it's been in operation for 2 different elections. So the idea that this is some massive intrusion upon the superintendent's authority is overblown. Your Honor asked the question, setting aside the idea that should people be handling these ballots at all, right? When you were listening to Mr. Kaplan's presentation. Well, the answer is they're already required to handle the paper ballots because the process requires that when the poll closes in the old rule, regardless of the hand count rule, they have to take the ballot box out of the scanner, they break the seal, they pick up those ballots, and then they put them into that container. Okay, so
That's pretty different from let's spread them out, piles of 50, 3 different people. Maybe we'll do it tomorrow. Yes, they're touching them, but that is a pretty minor from point A to point B, 2 seconds, done.
what I'm saying is that the same risk that you identified earlier, for instance, somebody might see that there's a lot of votes for so-and-so or such and such, and I'm going to take it, already exists. A lot of those issues already exist. Just as an aside too, there keeps being these references to these very old, infirm people who have been there for all day. And how can we possibly ask them to count for 15 or 25 minutes? And I take issue with the idea that you can't find 3 people who are willing to engage in an election day process and make sure that this reconciliation process can happen.
Isn't it though, let's just focus on Cobb, isn't it actually 444 people and not 3?
Correct, but correct. Yes, it is true
Okay.
that they have to have 3 people at each one of the precincts. But
Right.
the idea that, there are already volunteers there. There are people who have already taken the oaths and undergone the training. And all we have to do at this point is say, the three of you that we're going to take the ballot box out, if you're up for it, count them. If you're not, let us know. We'll find somebody else. That's it.
How do you find someone else?
The same way you found them in the first place. You solicit volunteers.
Okay. And so if they that night say, you know what, man, this took longer than I thought. I'm punching out. Polls have closed. See ya. I'm the poll manager. Who do I call to solve that? Do I call you?
Well,
Do I call the state election board? Secretary of State? Dang, there's just two of us now and I need three because that guy just left.
the same hypothetical applies regardless of whether these regulations go into effect or not. You still have to have two sworn witnesses that are part of the process of removing the ballot box. So if someone says, this has taken a long day, the polls stayed open an hour longer than I anticipated, I've got to go home, that same hypothetical still exists. And just on that point, since you brought it up, that is part of what is problematic with all of the affidavits that have been provided. It is littered with concern. It is concern. It is worry. If this were anything other than an election case with the public outrage that has existed, the type of affidavit that was submitted here would not be enough. Because all that it says over and over again is, quote, I am concerned about the rule's last minute adoption. I am concerned that the BOER will have difficulty identifying and deploying. I am concerned that the Cobb County Elections Office lacks space. I am concerned that the hand count rule may lead to delays. It's hypothetical on top of conjectures, on top of speculation. There is no imminent threat here. There is a threat of potential things that might happen if the worst case scenario comes up. And that's simply not sufficient for declaratory judgment. There was a statement by Mr. Kaplan that while it is theoretically possible to comply, we are concerned it's not practically impossible. We are concerned it is not practically impossible. Again, hypothetical, and it is again substituting the judgment of these individuals with the judgment in effect of the legislature through this secondary legislation. If I may also, and I know that everybody understands the language of the hand count rule, but I would submit to you that this is not Greek, such that it would take hours to train someone to do this. All that is added is that you remove the paper ballots, record the date and time that the ballot box was emptied, and present to 3 sworn precinct officers to independently count the total number of ballots removed from the scanner. That's enough instruction. That's not vague. That's not ambiguous. Sorting into stacks of 50 ballots, continuing until all ballots have been counted separately by each of the 3 poll officers. That's that. So that's the first part. You got to count them, separate them into stacks of 50. That's not Greek. That's not difficult to follow.
What about the separately and independently? Is it that each of the 3 starts with the whole pile and breaks them into 50? Or I'm the poll manager, I break them into 50 and then they verify? Or, I mean, none of it's Greek, you're right. Some of it strikes me as opaque with no guidance from the de-opaker, whether that would be the Secretary of State or someone else. So how would you train? Now you're apparently an expert trainer because you've concluded this would be easy to do for folks with unknown educational background who aren't getting paid a whole lot to do this, that they'll just pick it up like that. So instruct me on what it means to separately and independently count.
It means that each of the 3 poll workers have to count all of the ballots independently, sorting them into stacks of 50 and coming up with the same number. That's what it means. Whether you do it, as you said, with the poll manager, dividing them in half or in 3 parts and letting you start that way, that's up to the discretion there. That's fine. There cannot be regulations or legislation sufficient to cover every conceivable possibility or to govern every conceivable action that you might have to take. In fact, anytime that this board attempts to provide that clarity, there's a constitutional challenge and we're told there's an exceeding of authority. So the point remains, there can be some discretion into how that takes place. When all 3 poll officers arrive at the same ballot count, you sign the control document containing the polling place, ballot and serial number, election name, printed name with a signature and date. if the numbers don't, and this is the reconciliation part, that's it. That's what we are concerned about, that we can't do between now and election day. We cannot explain how to do that to 3 individual precinct workers.
So 444, what's the plan? What's the game plan to get that word out to 444 folks?
That is up to the individual county boards. They've got to do that. That's how they are. They're required to follow the regulations.
What's the wisdom? I agree, but you dumped a problem in their lap, not you personally, a few weeks before it needs to be put into operation. What's the wisdom of that? And what's the necessity for that, as opposed to, all right, let's make sure that we get to try this out, and this will be effective the next election?
To ask that question is to invade the province of the legislature through their rulemaking authority, the agency through their rulemaking authority. That is at the discretion of the legislature and the rulemaking authority. They're the ones that review all of the factual information and make the determination that this is practically impossible. It may be controversial. Some people say, I don't think I can do this.
But what you can't give no weight to the Secretary of State's perspective on that. There's a subject matter expert, and his considered opinion is this is too much too late. This isn't the time to pass rules like this. You're changing too much too late in the game. I'm not going to be the Secretary of State, am not going to be in a position to generate what I normally would, which is training materials, et cetera. So this isn't some reactive election board that never got along well with the state election board. This is Secretary of State, and this is his job to try to make this stuff work. And hopefully you're not suggesting that he has some agenda other than fair, legal, and orderly elections. And his considered opinion is too much too late. What's the response to that other than to say, well, that's his problem because the state election board passed these things, which is what you're saying when you say you got to get out of the way of this board that has been given the authority to do it, assuming it's authorized and it's reasonable.
Right, but the Secretary of State, I'm going to say what you told me I was going to say. The Secretary of State does not have rulemaking authority. They do not have legislative authority. They're not the ones that review the record. They're not the ones that are empowered to make a determination based on their review of the record. If it were the case that every time an agency official questioned the validity or the practicality or the reasonableness of something that they have some relationship to, such that it would give standing to the entities that are governed by those rules to challenge them, we'd be in litigation nonstop over things that are reserved to the legislature. And if this court is to accept these arguments, it is to substitute the Secretary of State's judgment or the county board's judgment with that of the legislature, and they cannot do that.
Clear. I'm not accepting arguments. I'm asking, how does one weigh it? It doesn't seem like it's an immaterial, irrelevant observation coming from the top legal officer in the state, the Attorney General's opinions. It also doesn't seem to be an immaterial, irrelevant observation coming from the Secretary of State that there are these concerns. And your answer, and it may be the answer you have to give, is to swat it away and say, you know what, everyone has an opinion. They don't merit consideration in this debate because the state election board has spoken. And I hear you, and that may be your response, which to me is non-responsive to how does a judge called upon to assess this weigh the concerns that were raised by the Attorney General and the Secretary of State. You and the board can choose to not pay attention to them. I don't know that I should ignore them, but it's not lost on me, your point. It's a very important point that the Secretary of State is not the one empowered to issue these rules. That's not his role at all. In fact, he takes them and he figures out how to help local boards implement them. So I get that. I'm not trying to turn the process on its head. There's no veto. And the Attorney General's memo was just that. It was his office's considered opinion about the validity of some of the steps that the board took. But like you said, it's not a veto.
I would refer you to OCGA 5013-19, which is the Administrative Practice Act. And the reason I keep coming back to this is because it determines what this court is constrained by. This court shall not substitute its judgment for that of the agency as to the weight of the evidence on questions of fact. And that is exactly what you are talking about. The weight of the evidence as to questions of fact. Is this practically possible? Do these county election boards have the time and resources necessary to do it? That's exactly what they were looking at in the administrative record. And that is precisely what the APA provides. This court cannot substitute its discretion for. You have to give deference to that.
Is there, you are much more familiar with the record that was before the state election board, but there's a robust record that they carefully considered the local election board's abilities to implement and comply with these rules? Or someone just said, like you've said, 14 minutes, what's the big deal?
I think there are something in the neighborhood of 1,500 pages of hearing transcripts. Part of Cobb County's exhibits includes an Open Records Act response that contains all of the emailed public commentary on it. I think it's 535 pages of emails, so it's thousands of emails.
Right, but that wasn't my question. I know there's a big record, but in directing me to 50-13-19, you correctly said courts are not supposed to substitute their judgment for findings of fact that the rule maker made. And then the natural flow from that is that they carefully considered a record that there's a basis from that record to conclude that these rules don't impose an unmanageable burden or an unclear burden on the local election boards. And I'm asking you to direct me to where in the record that is, as opposed to it's a big record. I know it's big, but it might be big because all the local election boards were saying, don't do this. That doesn't mean then that they carefully considered evidence that it wouldn't be an unreasonable burden with such short notice.
Sure. And I'm obviously I can't do that now. I don't have all of the transcripts, but I can certainly get you evidence of consideration of whether this is practical or not practical.
Okay, I get that, but you believe that that's in there. It wasn't, we heard all the naysayers, but we are yay sayers.
Yes, there were people who spoke out on behalf or in favor of it. There were people who spoke out against it. You've got people who are members of boards doing the same. So you've got both sides who are arguing about whether this makes sense or not. And based upon hearing all of that and considering all of that, they said this is practical.
Okay, I appreciate that there were pro and con. I get that. But what you said was that there was careful consideration of evidence that supports the notion that implementing these rules so close in time to an election was not an unreasonable or impractical burden on the local election boards. That's different from me appearing saying we need to have a hand count rule. It's one of the best ways to assure accuracy, that the total number of votes is what shows on the machine as well as the pieces of paper. And that may be true in a vacuum, but that's not what we're working through today. In fact, there may be plenty of people who would take no position adverse to a hand count rule had it been promulgated in February. But here we are. You're telling me that you're going to be able to find in the record a consideration of the practicality of this last minute implementation, not the practicality of the rule writ large. You help very eloquently at the beginning say, it's not counting who voted for whom, it's counting pieces of paper, and it's not all that burdensome. And the pushback from plaintiff was, well, I think they kept using that word immense burden, but in the end, it's more the practicalities of how do we get this thing off the ground in such a short amount of time? And that's where people are butting heads. You think the record will show there was robust discussion about pulling this off at the last minute, as opposed to what are the merits of this rule in a vacuum?
I don't know about the word robust, Your Honor, but I know that there's evidence that these types of considerations were discussed.
And it just needs to be some. It doesn't need to be robust. Okay, thank you.
Okay. There was reference to the potential conflict of the hand counting rule with OCGA 21-2420, which provides that the election superintendent shall then ensure all ballots are counted. That provision is talking about, in that context, the votes that are on the memory card. That's how they count the votes. They're not hand counting in that section. They're taking that memory card and they're getting the tabulation from the memory card. So there's no conflict there. Finally, and this goes back to our capacity to sue argument, and I'll be very brief because I know you've heard a lot on this. But the footnote in Floam that our friends on the other side say demonstrates that, of course, they can have standing. That's not at all what the footnote says. The footnote is in the context of a discussion about whether one of the plaintiffs had demonstrated evidence that they had a justiciable controversy or were facing some type of uncertainty. And the footnote in Floam simply says that as dicta, the Cobb County Board submitted an amicus brief that talked about how they're uncertain about what this other Board of Commissioners thing was done. And all the court said was, that's the type of uncertainty that we are concerned about. It has nothing to do with standing. It certainly has nothing to do with the capacity to sue argument that I've made already.
It's dicta either way.
Right.
Okay.
And that's it, Your Honor. I'm happy to answer any other questions, but that's what I have to affirmatively present.
Tell me, because you've heard me mention it several times, and you've had very good responses to this is why that's not a big deal. But there has been concern raised about the control document. And I may be using the wrong word, but whatever form is supposed to be completed by the poll manager when the hand count is complete. And that is my very limited understanding is that any form anyone is filling out in an election, the generic form comes from the Secretary of State. This came up in a parallel hearing about what does the certification look like?
Right.
Because I had this idea, like, why don't you just put on the certification? I have concerns about these things. And that's not what a certification form looks like. There's no blank for you to freeform your answer. Yes, I certify, but go check out precinct 9. I mean, I don't know what they were doing there, but that didn't look legit. And that's too bad, but that's not what a certification form looks like. And that's when I learned, because the board, a local board doesn't get to create its own certification form. It is given one. And so that same concern arose, like, well, what is this control document that a poll manager is to fill out if in completing its work, if that has to flow from the Secretary of State? And he has said, I'm not doing anything in connection with this rule. And that may be a chess game, like, haha, you can't fulfill this rule because you don't have a control document. Maybe that's a different declaratory judgment to tell the secretary, well, you got to create it because it's in a rule.
I'll be frank with you. I'm not familiar with that Secretary of State regulation. I need to take a look at it. I don't know.
I'm not citing you to one, but what the plaintiffs have said is we don't generate forms that document what happens in the election. Those come from the Secretary of State. And so there's a reference in the hand count rule to completing a control document that certifies, if you will, completion of the hand count. And so uncertainty abounds in some places. What control document? Who creates that? Will there be 148 different forms of a control document in Cobb County? And I thought that was one of the things you were going to pounce on to say, come on, control document. It's defined here in a different provision of that rule.
I don't know that it is defined in a different provision. To be frank, I see that when all 3 poll officers arrive at the same total ballot count independently, they shall each sign a control document containing the polling place, ballot scanner, serial number, election name, printed name, signature, and date and time.
Right.
I mean,
it tells you the contents, so it could be a piece of binder paper that has that info on it.
it's also not something that is actually, as I understand it, in any sort of certified recount or anything along those lines actually considered. What is considered are the ballots, the memory cards, et cetera. This is simply to document the process by which they've gone through this to make sure that the information from all of the ballot boxes and machines, et cetera, are on that piece of paper, but it's not actually reviewed and it's not part of any required review as dictated in the election code or the regulations themselves.
And what's the point of the rule?
It simply to ensure that, I mean, just to provide that information that you can only get from that place at that time, such that in reviewing all documents later, it's something that can be considered, but it's not part of a formal review.
So the control document, whatever that might look like, I agree, it's not part of the certification process. But if I'm bringing an election contest because of what I think didn't work well in that county, a control document might be a central piece of evidence because it says there were 47 precincts where they couldn't get the two numbers to match. It's not something that the superintendent relies upon in certifying, but I guess your argument in saying, well, why do we have this rule at all? Since you just told me, really, the control document doesn't matter. No one's going to pay attention to it. Is that hypothetically, it could be of value if there's an election contest and it could be evidence of systemic irregularities in a jurisdiction because there are multiple control documents that said, try as we could, we were -10. The machines were at 1,000 and we got 990 and we all got to 990. It wasn't even that I got to 989. All three of us got to 990 and the machine said 1,000. And that's a reason to think that there's some overcount going on. And strangely, all 10 of those went to the same candidate.
Your Honor, I don't actually see that the control document contains the number of ballots counted or anything about that. What I see that it talks about is the polling place, the ballot scanner serial number, the election name, and a printed name and signature, date and time of the ballot count, not information related to the ballot count.
So then how would, if I'm a poll manager and I can't resolve it, there's a discrepancy and we can't figure it out, how does word of that discrepancy go anywhere if it's not on the control document?
That's not what it talks about with respect to correcting an inconsistency. What it's talking about with respect to that is if the number is recorded on the precinct poll pads, ballot marking devices, and scanner recap forms, which are promulgated by the Secretary of State, do not reconcile with the hand count ballot totals, the poll manager shall immediately determine the reason for the inconsistency. So it has nothing to do with that control form that we referenced above. That has to do with reconciliation with the Secretary of State's form.
Okay, but I don't have the text in front of me. Assume you're right on that. I'm the poll manager and I can't reconcile it. And there are 10 more votes on the memory chip than I've got pieces of paper. Does the hand count rule empower me to tell anyone about that, require me to tell anyone about that? Or I leave frustrated. I did my job and it didn't work. Because if it's not going on that control document, where does it go?
Well, the poll manager shall immediately determine the reason for the inconsistency.
Yep.
i.e., are there still ballots in the machine?
Yep.
Correct it if possible.
Yep.
Find them if they're there, and fully document the inconsistency or problem along with any corrective measures taken.
Okay, but that's the circle I thought I was completing. That documenting the inconsistency, whether it could be resolved or not, doesn't go on the control document. That's a different document that would just stay with the poll manager or maybe go to the superintendent or?
Everything goes to the superintendent. That's a separate provision in the tabulating results provides that everything goes to the superintendent, except for obviously the machines themselves.
Sure. Okay. So this documentation of identified discrepancy and either successful investigation, there were things stuck in the machine, or unsuccessful, I can't explain why they don't match. That document would just be sort of swept up in the, please send everything to the superintendent that's elsewhere in the rule.
Correct. And that's the same language, remember, that we've already dealt with for 2 elections in a row with respect to a similar reconciliation of the ballots tabulated on the tabulation sheet and the check-ins.
Okay.
So this has already
That's
been
nothing
tested.
new.
This has already been tested. People understand their discretion within the context of counting to, compare that count to the tabulation tape. And that's it. That's the limit of your discretion. That's the limit of your obligation. And fully document the inconsistency or problem along the way is that same language has already been attended to.
Okay. So that wouldn't be something new for a poll manager. I've had to do this before in a slightly different context concerning the recap form.
Correct.
And now whatever toolkit I developed to do it, I apply it to the hand count that we're doing of the ballots.
Correct.
Okay. And so what would be new along with the hand count would be this control document, which, as you pointed out, doesn't actually include there was an inconsistency. It says these are the machines basically that for which we were counting ballots and the date we did it.
Correct.
Okay. All right. Thank you.
Thank you.
Mr. Kaplan, anything you want to say as we wrap up?
Just very briefly, Your Honor, a couple of points. I think the State Election Board's presentation and certainly some of the responses to Your Honor's very fair questions really raised more questions about the meaning, interpretation, ambiguity of the hand count rule than we started with. I think the answer to, well, how do you count in stacks of 50? What does separate and independent mean? I think the answer was essentially it's up to the poll manager. That could lead to thousands of different people making decisions about how to do this count. That does not promote uniformity, does not promote consistency in the administration of election. It's contrary to the SEB.
What about Mr. Thomas's observation is I think he got frustrated with me pressing that like, hey, you can't, but I agreed with his answer. You can't write a rule that thinks of every permutation. And so, hey, we're saying generically, you can't, the three of you can't just sit there together and watch one person count and say, yeah, we all got the same number. Because when two are stuck together, you're missing those two other opportunities to not have those pieces of paper stuck together. And so this is adequate. It may be if you're in precinct 9, it looks a little bit different than in precinct 14, but in the end, 3 people have counted, and if they can reconcile it, they're able to say, the machine said 700 ballots, we counted 700 ballots.
Yeah.
Job done.
Well, we would say that, for all the reasons that have already been argued, they don't have the authority to promulgate the rule in the first place, so it doesn't matter really that this rule is somewhat ambiguous. They're just inventing a new process that the legislature did not, despite setting forth very specifically the way an election is conducted, the way a count is conducted, making very clear that counting of ballots is done as soon as possible and shall not cease. So we don't think that they can just invent a new, slightly or highly ambiguous rule and just throw up their hands and say, we don't have to tell poll managers everything. We can just come up with new stuff and let them figure it out. That's essentially what you've heard today. That is inconsistent with their statutory authority, but it's certainly inconsistent with their obligation to implement rules that ensure an orderly election and ensure consistency among superintendents and ensure uniformity. What you heard was the opposite of uniformity. It's let them figure it out for themselves. And the timing of this is what makes it problematic. Is it possible that, the state election board could adopt some rule that it's otherwise authorized to adopt that has some ambiguity? Yes, but you do that far enough in advance of an election so that you can sort through those ambiguities and you can get Secretary of State guidance and training so that the election is done uniformly. So if there is 2 possible ways to create a control form, let's say, as Your Honor has put out or pointed out, then the Secretary of State under the law, and this is OCGA 20-2-50A5, is statutorily responsible for creating all blank forms for an election. So yes, they have identified a form that needs to be made, but there needs to be time for the Secretary of State to also do its job, which is to create the form to ensure uniformity. There isn't time for that.
What was the statute?
This is OCGA 21-2-50A5.
Okay.
And that imposes exclusively within the Secretary of State's discretion, the creation of all blank forms to be used in an election. Other questions, and this is as my client listened to the argument, some comments that were made. The question of write-in ballots is of great concern to my client. write-in
Question of
ballots.
what?
Write-in ballots. So this election, we actually have, I think, one permitted write-in candidate. and
Oh,
people can-
write-in ballots.
Yes, write-in ballots.
Okay.
And so when you cast a voter, at least you type in the name of a person you want to write in, which many voters do. That creates a paper ballot that is essentially a BMD ballot, and that's fed through the optical scanner. But optical scanners, they try to sort between the ballots that are cast based upon solely non-write-in candidates who are on the ballot, and ballots that contain write-in candidates. And the ballots that contain write-in candidates are separated typically and historically, and still sealed and immediately delivered with the memory card to the tabulation center. And then the tabulation center processes those ballots with particular carefulness, because often those require additional levels of review to ensure that a voter is not disenfranchised by not counting the vote for their write-in candidate. Well, this hand count rule doesn't say anything about what to do about the typical process of, a traditional ballot with candidates who are on the ballot form and write-in ballots. And do you just stack them all together in a stack of 2,000? Can you maintain, a separate stack if there are only 5 write-in ballots? Because you have to count in stacks of 50.
Is the segregation of write-in ballots in the way you described just a best practice, or are there rules or regulations that direct poll workers and superintendents to keep the write-in ballots separate from non-write-in ballots?
That's a good question, and I don't know that I'm sure there are specific rules with respect to write-in ballots, but I'm not familiar with the specifics. But certainly every county and every precinct faces this issue, and there's no question that, I think the optical scanners that are used are designed to separate them so that you can maintain that difference. And the point here is not, does this rule conflict with some specific treatment of write-in ballots? It simply is silent on how to address the issue of separating write-in ballots from traditional ballots. And it totally disrupts what has been the traditional process, certainly in Cobb County, of getting all of the election materials together, which include the memory card, which include the paper ballots, and sealing those up, making sure that you have a very solid chain of custody, and you bring those to the central office or the tabulation center, where the election superintendent is ultimately authorized under the law to oversee the process of reconciliation and counting. This disrupts that entire flow by separating potentially the paper ballots from the memory card, as Your Honor was asking about earlier, and not providing any insight into how to treat the difference between write-in ballots and traditional ballots during the hand counting process, and is utterly unsupported at all in the election code, as noted by the Attorney General. We didn't hear anything about the concerns that we've raised with respect to, well, one other point here. The rule also does not address this question. What if you have a scanner that has more than 750 ballots that have been scanned, and you have a scanner that has less in a single precinct? So then the poll manager under the rule could theoretically choose to count the ballots from the more than 750 scanner the next day, but would have to maybe count the first set of ballots that day. It's just not clear, because the rule seems to pertain to a single scanner and the number of ballots with respect to a single scanner. But many precincts have more than one scanner because, they involve a lot of voters.
Sure. What does your client tell you, or your work on this case tell you? Let's say that was the only issue with this rule, that actually otherwise people hand count, let's do it. It's another check. Why not take another check to make sure counts are accurate? But we have a bunch of precincts where some machines will have 800 and some will have 200. And I just don't know how to manage that. Do I have to do the 800 at a later date? And so we're sending in 2 different batches. Let's say that was the only issue. where would your client go for relief and answer on how to manage that?
And I think the typical process would be through the Secretary of State and through a training process and through a uniform, consistent understanding where election officials across the state, the election directors from each county, or if the boards decide to get involved because it's an important enough issue, the board itself would combine in meetings that happen, in the year prior to an election. And as Ms. Silas's affidavit sets forth, I mean, we start the work to prepare, particularly for a presidential election, a year before. This work started in 2023. And that's the kind of thing that happens. The election officials from across the state get together, often in meetings facilitated by the Secretary of State. Secretary of State provides guidance, training materials, and other information. And to the extent that there's a sufficient enough ambiguity, then you might go back to the state election board. You might seek declaration from a court of law. But, in a standard process, there's time to work through those things to ensure consistency, uniformity, as required by the state election code.
But your understanding is that even though the Secretary of State is not a rule maker, his office might provide training or guidance on what to do with that scenario of one machine has 800 and one machine has 400. That the general approach is X. And I guess if a local election board said, I don't think that's right, ultimately everything could go back to the rule maker to say, there's this piece that wasn't in there. I know you can't contemplate everything, but this is sufficiently recurring in larger counties, Chatham and Macon, et cetera, that we need more specific guidance on what to do when you've got one machine with 800 and another with 400.
Right, and that's assuming that the state election board even had the authority to adopt it in the first place. And
I'm assuming, my hypothetical was the rule is all good, and we're running into, you have highlighted a bunch of areas of ambiguity that are created by the hand count rule. And I just simply want to understand, how does a client like yours navigate it if the rule itself is unobjectionable, it's passed with authority and timely, properly noticed, all those things, but then they're thinking about how are we going to implement it because it's passed in February. Wait a minute, what about 800 in one machine, 400 in another?
That's right.
How do you solve that? And you're saying you could go to Secretary of State, or it could be that if enough local boards bubble it up to the state board, they could amend again. So you know what? We didn't think through that scenario. So here is a tweak to subparagraph 5. Here's what you do. It's your total count. It's not by a machine. If you have more than 750 paper ballots, then you can kick it to the next day if you need to.
That's right. And there's also, beyond sufficient time to have Secretary of State guidance and training, sorting through any other issues, the state election code contemplates that any really detailed issues regarding reconciliation or tabulation are administered and supervised by the election superintendent, by our client, not by individual decision-making by poll managers. And yet this rule, in terms of deciding what to do if you have a scanner with 800 ballots and a scanner with 700 ballots, would leave that question solely to the discretion of either the poll manager or even an assistant poll manager.
Mr. Thomas helpfully, for me, pointed out that some of the concerning language for your client in sub 5 is in sub 2, where poll managers, when they're working on the recap form, if things don't reconcile, they should, and it's the same language, determine the reason for the inconsistency, correct it if they can, and then document it. So it's A2 in the tabulating results rule, paragraph A2. You handed it to me. And that doesn't seem to have created heartburn for superintendents around the state before.
So are you talking about, sorry,
And it may be that
7 of the binder that
I don't know. You handed to me independently. Here's the current.
the tabulating results rule?
Yes,
Right. And
correct.
I believe that's A1. right?
A2. Look at A2. The final sentence in A2.
I'm just making sure I'm looking at the same rule.
This is the unamended version of,
I see, the prior rule.
well, it's the current rule until the 22nd.
That's right. You're exactly right. So as I understand it, I'm looking at this now, the poll manager shall, basically is taking the number of check-ins and providing essentially the reasons for any disparity between the number of check-ins, which is a number already in existence, and the number of scanned and recorded.
Right. And I'm not asking you to decide on the fly, but the point is there's a poll manager role that's been out there for at least 2 election cycles that involves some data reconciliation.
Sure,
And if
and
it
that's
doesn't
always been true, no doubt. And,
Okay.
and look, there are other examples, and we can look at also, other rules in here. I think behind Exhibit 7 is the A1 of that, and it also has examples where poll workers, managers document reasons for inconsistencies. That's in the statute. That doesn't involve the creation of an entirely new form of counting ballots or disrupting an existing process. That is a requirement to basically document information that they are aware of so that when that information is sent to the superintendent has the benefit of any detailed, precinct level information that is a part of the normal existing process. So, I mean, and of course, we have been trained on pre-existing rules in that respect. And perhaps my colleague, if you have specific questions about how we do that, it's certainly true that in terms of the recap form, if there's a poll manager who understands that there's some difference between, the number of check-ins, the number of BMD counts, they would have a way, and they've already been trained on a way of documenting any knowledge they may have about that. But that is far different from creating an entirely new hand counting procedure.
Okay, I appreciate there's a
Yeah.
distinction, but one of the arguments you've been making is this usurpation of authority and responsibility by the poll manager. I mean, it's created by the rule. I'm not saying there's been a coup here, but that the rule improperly pulls authority, supervisory authority from the superintendent and gives it to a poll manager. And Mr. Thomas's point was, that's happened before, and boy, there were no lawsuits about that. And that's in A2, where it's not the superintendent's job, but it is the poll manager's job to work through inconsistencies. And so that very same language was cut and pasted into proposed A5. I'm not saying, does it
Sure.
make sense to be handling ballots and the chain of custody issues, but one of your arguments has been the authority to resolve inconsistencies and sort this out. That's a superintendent type job. Mr. Thomas said, well, apparently not always, because look at A2.
Well, sure, things happen on the precinct level.
Okay.
I read this rule a little bit more as we were engaging, and my understanding is, I mean, the current trained process is you have a series of counts, and I think we heard more from Mr. Varghese about this, but, there's voter check-ins, then once a voter actually, presses the button to select their candidate and a ballot is printed, the vote is not actually cast yet, but it's printed, and and that's called the BMD number. And then the voter walks that piece of paper to the optical scanner and then scans the ballot. And there's another number for that. And currently we are well trained on how to include in a control document those numbers. And to the extent there's one more check-in than there was a BMD, we try to figure out if we can explain it. Sometimes a voter does check in and then decide not to cast a ballot.
Right.
And so if we have knowledge of that, we would write that down, because that would explain why there was a check-in, but there wasn't a BMD number. Or if there was somebody who printed a ballot and scanned it, and then, the ballot didn't scan properly or something like that. And, we can try to make sure it's scanned properly and document what we do. Those are all things that are true at the precinct level and do involve documentation and do involve the recording of information, and are matters that our poll officials have long been trained on and know how to do. But what is referenced in this rule is entirely new. There's a new control form that relates to a hand count. The Secretary of State has not issued that. And
Okay,
there's
I
a
get the new
process.
part. I'm hearing you say,
That's
maybe
right.
with training, there'd be less of a concern about this delegation because we already have poll managers doing similar reconciliation.
That's right. And I have a citation for you. So the statute addressing write-in ballots is OCGA 21-483, and this is actually behind tab 11. of the authorities binder, and it provides that write-in ballots are adjudicated differently via duplication panel, and they must be kept separate. So dealing with write-in ballots is simply unaddressed by the hand count.
You said it's 483?
Yes, Your Honor.
Okay,
And that's behind tab 11.
okay.
The other point here, since we're talking about the substance, is, you know, a lot was made of the suggestion that there's some average. The average is only some, you know, fraction of our typical precincts. Most of our precincts have more than 1,000 voters, at least as of 2 elections ago. And so there would be situations in which an individual poll manager could make the decision to potentially count later. And that's more than half of our 148 precincts. So, you know, the
If everyone
prospect,
voted on election day as opposed to early voting or mail-in.
that's correct. And so if a poll manager decides to conduct the hand count the next day, let's say most of the poll managers of those 80 precincts with more than 1,000 voters make that decision, then those same poll managers, presumably under the rule, have to go to the central office the next day. And then you have a scenario where there are potentially dozens, upwards of 50 different groups of 3. We have not, you know, you have to figure out, well, how do you assess the public access part of this? All of this planning, again, goes back to the point that, you know, having advance notice and doing this consistent with the way things are typically done in elections administration would be much more consistent with the state election code, as well as the authorities set forth in the enabling legislation for the state election board. Your Honor, interestingly, we heard nothing from the state in response to our procedural challenges of these rules. I don't believe I heard argument regarding why it was okay for the board to not notify the public that it was taking a vote on these rules. We also heard no response to the failure by the board to state the differences correctly. That entire issue seems to not have been addressed. I'll conclude with this, Your Honor. I believe it was this morning that you issued your decision in Adams. And in that decision, I believe it was on page 5, you emphasized that the certainty of the electoral process that the laws, meaning the state election code, has long brought to voters has begun to unravel as key participants in the state's election management system have increasingly sought to impose their own rules and approaches that are either inconsistent or flatly contrary to the letter of these laws. You issued that decision in regards to rulemaking on the certification rule that also happened just several weeks or months before this election. I would submit that the rule, particularly the hand count rule at issue in this case, falls squarely within Your Honor's expressed concerns in your order of today and would even further disrupt the administration of this coming presidential election, would lead to disuniformity in this election and inconsistency among the counties. And for that reason, we ask that you today enjoin the rule and declare that not only is the hand count rule, but the other 5 rules are invalid. Thank you.
Mr. Kaplan?
Your Honor, I'm sorry. I realize I did not address the APA, and if I could have the opportunity in maybe 30 seconds to do that.
Okay, and I forgot, there were 2 forgetfuls. I forgot to call upon Mr. Kaufman to present the views of his client as a intervener defendant. So why don't I let him go first, because that may trigger something else you want to cover, okay? Mr. Kaufman, I apologize.
Thank you, Your Honor. My colleague we're splitting our argument a little bit with my colleague Kevin Preachard.
Okay, your short argument?
A short argument,
All
yes,
right.
Your Honor. I could take a hint, right?
No hint.
No hint. Sort of on a high level, we hear a lot about, well, we don't have any rules, we don't have any guidance, but it's sort of a self-fulfilling prophecy when
Blake Evans's letter on behalf of the Secretary of State said, we're not going to issue it until you're finished your litigation. So that's sort of the chicken or egg. And that goes into the issue of the Secretary of State didn't say, we won't do it, we can't do it. He said, we'll do it as soon as this litigation is resolved, depending on how it's resolved. I would also point out to the court, as the court's already noted, that there's an Attorney General memo. It's not an opinion, official opinion. It doesn't host any of those things. And you know, in other cases, the AG's actually said, look, I have a conflict because of these internal memos. So he's also responsible to the SEB. So I think that's important. The other thing, which ironically Cobb County's brought up, is OCGA 21-248-483, which is counting of ballots, public accessibility to tabulating center and precincts continuing. And that's really where we get into where these rules really apply in 21-243 and 484. The first one, 483A, in primaries and elections in which optical scanners are used, the ballot shall be counted at the precinct or tabulating center under the direction of the superintendent. All persons who perform any duties at the tabulating center shall be deputized by the superintendent, and only persons so deputized shall touch any ballot, container, paper, or machine utilized in the conduct of the count, or be permitted to be inside the area designated for officers deputized to conduct the count. So the statute already contemplates counting of ballots, again, not a result, but a counting of the ballot, to be held at the precinct. There's nothing new here. The State Election Board only promulgated a rule that says this is sort of how we expect you to do it, waiting on the Secretary of State, notably no longer on the State Election Board, to promulgate guidance and training. Of course, only delay is based upon Cobb County's suit, which we can agree with the State Election Board. They lack the standing, and the standing argument is something that Mr. Kucharz will handle. And the second rule, we talked about one of the six, so now we've addressed counting, but the other rule of access, poll watcher access, B, under 483, all proceedings at the tabulating center and precincts shall be open to the view of the public, but no person except one employed and designated for the purpose of the superintendent or the superintendent's authorized deputy shall touch any ballot or ballot container. Again, this rule doesn't violate it. It just clarifies what is already there, that you have access.
Well, except you tripped into one that I didn't hear much from plaintiffs, but they flagged, which is none of these people who will be touching ballots are deputized. And B says no one should touch it unless they've been deputized.
Well, I argue that anyone working at the precinct as a poll manager and poll watcher arguably has been deputized with that responsibility from the superintendent, or the superintendent, it's inferred, needs to go ahead and make that deputization.
Okay, you argue that, but I don't know that that's how it plays out. But I hear you.
Well, it already says that they're there to count, because if you go to 484, which I'll note to the court, this is in the ballot recap form and delivery. It says that upon completion of voting, the manager, meaning the precinct manager, shall prepare and sign a ballot recap form in sufficient counterparts, showing one, the number of valid ballots, including any that are damaged. Arguably, they would have to touch them and count them. Here, again, we've just clarified by SEB rule how those valid ballots are counted. The number of spoiled and invalid ballots, and the number of unused ballots. And then you go on to saying the manager shall then place one copy of the recap form and defective, spoiled, and invalid ballots, each enclosed in an envelope in the ballot container. Clearly, they're touching them already. And if anything, this form that the court has noted, we've yet to see, is only one further way of recording the chain of custody. It's no different than any other chain of custody issue. But there's no different people. It hasn't left a group of folks. So I don't see that as counter. And then if we look at 21-2-485 under responsibilities of poll officers, as soon as the polls are closed and the last elector is voted in precincts in which optical scanners are used, the poll officers shall. And then it lists a whole litany of these responsibilities of what they do. None of which we believe is violated by the SEB rules or the SEB rules creating anything new that's outside of the statute. It gives clarifications. I'd also note that the state election board's charge is to create uniformity and as well as fairness, correct? And so many counties already are doing these exact things. They already are counting to make sure they have enough. So you have some counties doing it, some not doing it. They already have some counties that are posting per the posting rule
I
online.
may interrupt you here. So I don't know that you're saying these things. Is there evidence in the record before me that there are counties who currently hand count in a manner
Yes.
required by this rule?
I believe it's in the SEB rule minutes from when they were promulgating the rules that there was testimony from certain counties that they are already doing this. And again, that I think bears light on this whole idea that, oh, it's not feasible. Well, it's clearly feasible for some counties, and we would show that would certainly give credence to the idea that uniformity being the charge of the SEB, there's no rule that says thou shall not do it. So you're in an interesting situation. Additionally, some counties, over about half, post the results on their county website at the precinct level as promulgated in this rule. So again, you're at this idea of uniformity being at issue. And of course, there's a discretion at every precinct on how poll watchers or how close can they get, where do they get to go, what is reasonable access. So here, I believe the SEB has tried to fulfill its charge of creating uniformity throughout the state of Georgia. The next thing I want to address is they've brought a TRO, which of course is the same standards of immediate, irrevocable, not readily compensable by money, and not violative of public policy. Well, I would argue that the immediacy issue is we're not right up at the cliff at the moment. Yes, we're getting close, but there's nothing that if the court ends this case that the Secretary of State has not said I am unable to make rules and not unable to create guidance or to teach. And of course, most of what we're talking about is stacking things into piles of 50 and counting to 50, which again, we've addressed in 43, 44. I would argue that it's already contemplated under the code, and presumably every member, poll watcher, and poll manager has been vetted and has signed an oath that they are competent, they're not criminals and whatnot. And so I don't think this is a major ask to count. Again, it fills our public policy of having meaningful access to poll watchers so that they can count stacks of 50, gives them an idea of that this is valid versus some massive stack, or here we just never even did anything, just stuck it in one bin to another.
What's the gain of the process if it doesn't become part of the certification process?
Well, I'm not sure it doesn't.
So walk me through how it does.
Sure. Well, for example, in the election code, the superintendent, if they believe that there is fraud, irregularities, misconduct, or errors, they're entitled specifically to summon the poll manager to explain why there is this deviation.
Right. So let's talk about uniformity here. Since the rule doesn't require that the results be reported somewhere or be acted upon, doesn't it then become really up to the superintendent to decide, that poll manager, he never could count anyway, and so I'm going to disregard this report, or I get one and I'm going to take, because I've got one, there must be a problem everywhere. And
Well, I think
there's a lot of passion behind this, and for good reason. It just was surprising as we as a group suss this out. What's the so what of the rule? And the so what of the rule is a poll manager might conclude there was an inconsistency. There were 800 ballots listed on the microchip, and we only counted 790. There's not a defined mechanism, what you do with that news. And there's no requirement through this rule or any parallel rule that the superintendent must do something about that or anything like that. And so why go through the exercise if it doesn't have that final hook to say, when this happens, if there is an inconsistency you can't resolve, you press this red button and we've got a reason to be worried about it.
Sure. And I think I can answer that question, Your Honor, and that's because there was no need for the rule because there's statute under OCGA 21-2493 B, which is under the computation, canvassing, and tabulation of returns, investigation of discrepancies in vote counts, recount procedure, pilot programs, and whatnot. And so specifically under B, they talk about overvotes and undervotes with excesses based upon the precinct level. And in fact, it reads, the superintendent, before computing the votes cast in any precinct, shall compare the registration figures with the certificates returned by the poll officers. Again, it's undefined term certificates. I would argue this new one could possibly be concluded, showing the number of persons who voted in each precinct or the number of ballots cast. If upon consideration by the superintendent of the returns and certificates before him or her from any precinct, it shall appear that the total vote returned for any candidate or candidates for the same office or nomination or on any question exceeds the number of electors in such precinct or exceeds the total number of persons who voted in such precinct or the total number of ballots cast therein, such excess shall be deemed a discrepancy and palpable error and shall be investigated by the superintendent.
So it flows into that. The
Correct.
notice that would come from a poll manager that we had an inconsistency that couldn't be resolved would be a 493B alert.
Exactly. And it specifically continues, it says, and no votes shall be recorded from such precinct until investigation shall be had. And continues on.
I'm familiar.
We're pretty familiar. We
Yeah.
spent a little time with it last week, as
Yeah.
I recall, Your Honor. But to answer your question, that's why. And again, it also fulfills the public policy, which since 2020, the legislature has taken pains to try to give voter confidence in the election. And this is one more step to go, here we go. Additionally, they've isolated it by precinct, again, for the 493B purpose, but also if there is an election challenge, there's evidence that can be found in a much easier and readily available way for a candidate or party and that's significant because once it leaves the precinct and ends up at the tabulation center and then ultimately dumped into one giant pile, it becomes a very difficult process. And as the court just ruled today, as we all agreed, consented at the Adams hearing last week or 2 weeks ago, that certification is mandatory within the time frame. That now you would be
all agreed.
fully agreed on certification. That at that point, then it now will be triggering the challenge purpose. And so that is partly why now you've isolated, because when you have to bring a challenge within 5 days after certification, it's a near impossible process, especially on a larger scale with a big county or statewide. So those are all reasons why that rule, I believe, in particular, the hand count rule, has some great validity as to under the public policy. So we don't believe that this rule is violative of public policy. If anything, in joining the rule would violate the public policy that's the overarching, which has been to have more transparency in the election process. And again, they've talked about funds and costs. Well, that's compensable by money, so that they are going to fail on at least 3 of the tenets of what is required under a TRO. The last quick issue, because I am trying to be brief with the court, and I know the court's studied up and intimately familiar with this issue, but we've heard this sort of quasi-Purcell doctrine. Well, specifically, Purcell is applicable to courts. It's not applicable for courts to make changes. Additionally, it's an impact on the voters. None of these rules impact the voter. Most of these are having to do with post-election, how we're counting post-election. So it's not impacting the voter. It doesn't cause confusion to the voter. And I would also point out to the court that as recently as 2020, the State Election Board created rules much later in time affecting the 2020 election than what we've had this year in 2024.
How could it be later?
They were last minute rules during COVID and
The day of the election?
well, it was a little later. And again, these rules have been in the works for long periods of time. They were certainly administrative hurdles due to internal conflicts, between the SOS, the SCB, the Attorney General, but it had nothing to do with the SEB's bringing notice of these rules and going forward, as well as we've talked a little bit about strict and exact compliance, but at the end of the day, the public was aware, these are the rules, these are the topics, and the SEB has always, they didn't deviate from how it has operated. And I think that's significant. Maybe it's not the best practice of how it should be operating with today we're talking and then we're voting, but there was no deviation. There was certainly a lack of public notice or comment. We've talked about the thousands of pages and open meetings, and most of these took 2 days and were significant in that nature. So
I don't know that it becomes okay because it was always wrong, and so it was still wrong in terms of notice. I don't know what kind of argument that is. Like, well, we never got it right, so don't hold us on this one, because we never ever told anyone when we were going to adopt rules. We always just said, here's when we're going to discuss rules.
Well, they had gone through a pattern of practice of giving notice of the rule, discussing it, and then a waiting period and voting. I don't think that none of that has changed here. But
if it wasn't compliant with the APA to begin with, it doesn't somehow, it's not like there's laches here and these folks can't argue that it was inconsistent with the APA because it's happened in the past that notice wasn't provided, that now this meeting, we're going to we're going to vote up or down on the rule. That's all I'm saying, is it may well be that for the last couple of years, the only notices say, today we're going to discuss these things, or we're going to accept comments on. But if the rule is you actually need to be more specific and say, on this day, we are going to vote up or down on this. The fact that that didn't happen isn't okay just because it never happened before. It was always wrong if that's what the rules are. And it was fairly persuasive that you, in fact, need to give notice more specifically than, we're going to be thinking about these things today.
Well, I'm not going to concede that they didn't comply with the APA. My point was that there was no deviation in practice. I mean, if taking that argument to the most extreme, then every rule ever promulgated by the SEB since practice for years should be invalidated.
Or could be. Who knows?
Could be.
Right.
Yeah. I don't think that's really what occurred. This is standard notice. No one has yelled surprise or but for. If had I known this wouldn't have occurred, or that's not really what it is. And then again, you go into the standing argument as to is Cobb County Election Board or my Democratic colleagues the proper party to even bring that, and that goes into the standing, which if the court doesn't have any other questions, I'll yield the well to my colleague.
Please do. Thank you.
Good afternoon, Your Honor.
Good afternoon.
Kevin Kuchars, nice to be in front of you. And I can be even briefer than I think probably anybody else. I'm going to talk about standing, but before I get there, I wanted to touch on one issue that I anticipated being discussed but hadn't been. And that was the issue of the delegation of authority to the election board. And the way that the rulemaking authority statute has been described has been just providing for uniformity in practices. Well, I would suggest that if we look at the rule itself, it says to promote rules and regulations so as to obtain uniformity in the practices, et cetera, et cetera. But then it goes on to say, as well as the legality and purity in all primaries and elections. Now,
that P word, to me, that's a funny word for, what's a pure, that's sort of like, have you had relations with someone before?
I don't
know that any election is pure. Good luck with that.
It's funny you say that. I had in my notes, I'm like, it's a colorful word.
It is a colorful word.
It's not one I would have used, but I understand.
It's there.
I understand what they mean and what they're getting at. In this context, it has to be read as delegating authority to the election board to promote and promulgate and enact rules that they believe will lead to greater confidence in election security and actually in promoting the integrity of the results that are actually reported. So to suggest that there is no rulemaking authority that's been delegated, I think is frankly incorrect. Now, is that delegation of rulemaking authority too broad? That question is not before the court. There may be a proper action to bring that at some point, but it just isn't that statute is not being questioned here. There's no question. Nobody's standing here today saying that statute is unconstitutional. This would not be the proper action to do that. So based on the law, the election board did have authority to make that judgment call that they needed to take action to promote the purity, we'll keep using that word, of the election process by enacting rules like the hand count rule. And that's really all I wanted to say on that point.
Okay.
Okay.
I'm glad someone brought up purity.
All right, moving on to really just circling back to the motion to dismiss. Your Honor, I appreciate you having read the motion. I know it was filed on short notice, but based on your questioning to the petitioners, I could tell that you understood our arguments, so I can keep this very brief. What we're dealing with here is a request for an advisory opinion. There's no uncertainty as to what they're required to do. There's no uncertainty as to whether the Cobb County Board will get punished for making the wrong decision. They know exactly how that would play out, and there's no uncertainty that needs to be resolved through a declaratory judgment action. The uncertainty that they've talked about is uncertainty as to whether the rules were properly enacted. Well, that's not the type of uncertainty that this particular petitioner could challenge in a declaratory judgment action. They've also talked about there's uncertainty as to whether the board exceeded their delegated authority. I think my first part of my argument covered that a little bit, but again, it's not the type of issue that the Cobb County Board can challenge in this action. Going back to, I think it was your first question, what is the legal right that the Cobb County Board actually has here? There is no legal right that I've even heard them claim that they don't have to comply with lawfully promulgated rules of the election board. There is no legal right for them to decide in advance, hey, maybe this rule will get overturned down the line, and we want to go ahead and decide not to enforce it or to get an opinion that we don't have to. So again, it is a fundamental point. The nature of declaratory judgment action, you need to have a legal right. And actually, legal right is also in the sovereign immunity waiver, the 50-1310. So to the extent there isn't a legal right, they don't even have the ability to bring suit here. So in the absence of an articulated legal right, they simply can't bring this action. There may be a proper action in which a proper party could challenge it, but it isn't here. And again, another component is there is no jeopardy. I kind of touched on this, but let's say they make a mistake. Let's say they do something wrong. Nothing's going to happen to them. They point to that one statute that says, well, if we make 3 mistakes over a certain period of time, we could potentially lose our ability to do our job. Well, that statute written into it, there's an exculpatory outlet. They only get punished if they don't fix their mistakes. So if they continue to willfully make mistakes, then they could get punished. But there is no jeopardy that attaches to any right that's been asserted here that would enable them to bring a declaratory judgment action. And finally, I'll say, Your Honor, this case could very well set depending on your ruling, if you rule for the petitioners, I'll probably be citing the opinion in cases where I want to bring a declaratory judgment action, because I think permitting this would significantly broaden the scope of the types of declaratory judgment actions that you could bring. So, the old maxim of expediency or, difficult cases bring bad rulings. I think we're very much at risk of having one here. So a final point, Mr. Kaufman talked about it, but promoting confidence. You said it yourself, the rules, particularly the hand count rule, were intended to promote fidelity. And, that's why waiting till next year isn't good enough. It would be easier for everybody. It would, resolve a lot of difficulties, clear the court's docket, understandably. But fidelity is an important concern, and it's the reason why just kicking the can down the road just isn't good enough here. Georgia, as we all know, has had its election integrity called into question in the recent past. And certainly, I would suggest that a rule which is intended to promote fidelity in this upcoming election that gets kicked out at the last minute will severely undermine voter confidence. And everybody's watching. This is going to be in the news, and I think it could lead to some bad results. That's all I have unless Your Honor has any questions.
I'm good. Thank you. Appreciate it. Uh-oh. What does your cell phone tell you?
It's well past lunch, Your Honor. No.
Yeah, and my stomach tells me that.
I just would request, you had asked on the agenda meetings, and I would stand on my place to say that the agenda from September 20th says discussion and voting, and then lists the proposed rules. I would ask that we be able to at least keep the record open so we could supplement I believe they're 8038 exceptions since they're public documents, but I'm happy to send it to all council for their approval if they don't have an objection, to send in the meeting notices from the state election board with the agenda.
Agenda or notice? I'm looking at the notice for the September 20th meeting, and it is to provide the public, this is Petitioners Exhibit 2, we all looked at it.
Yeah.
To provide the public an opportunity to comment upon and provide input into proposed rule amendments. Turns out one of them wasn't an amendment, it was an entirely new rule. But either way, doesn't say anything about voting. If the agenda that's published when? The day of the meeting, the day before?
I think it's a few days before, Your Honor.
Your argument is that's the notice to the public?
No, my point is, I think it should be at least that this is the entire notice, and because some of these rules were carried over from the August agenda as well, and so that's why I'd like to put all three of the agendas into the record with the court's permission.
Okay. If you can get copies of those to all the other lawyers, I think it makes sense to have a full and complete record.
Okay, thank you.
You bet. Mr. Thomas, you were reminded of arguments you didn't make by Mr. Kaplan. So, yeah, exactly. You were sitting pretty. I'm like, damn, they are scared of those arguments. He didn't even touch them. But now you're going to touch them.
And I'll be very brief.
Okay.
The statute that they're citing, it says prior to the adoption.
What is that statute?
5013-4. Subsection A says, prior to the adoption, amendment, or repeal of any rule. Subsection E is the exact compliance section, and it says, E, that no rule adopted shall be valid unless in exact compliance. It does not say that no rule amended, D, shall be in exact compliance. And the Court of Appeals in Corner versus State, 223 Georgia Appellate 353, a 1996 decision said that strict compliance is only necessary when a rule is being adopted, not amended.
Can you give me that site again?
223
223.
Georgia Appeals.
Yep.
353.
353. Okay.
And it further says that it's not, the question is not only whether they substantially complied, which is what the court identifies as the standard, but also whether there has been a demonstration of, quote, substantial harm. So that's all I would say in response to all of that.
Okay. That second piece is sort of what I was waiting for. I mean, there's exact compliance, but if a comma was missing and there's no harm, that seems like a rather draconian approach. Thank you.
Brief response on that, Your Honor. One citation.
Response to which? I just heard from three lawyers.
Just the citation of Corner versus State.
The 223 Georgia Appeals?
Yes, sir.
Okay.
So that's a Court of Appeals decision. Since then, the Georgia Supreme Court and Outdoor Advertisers Association versus Department of Transportation. Sorry, that's not Supreme. This is also a Court of Appeals case said, quote, failure to comply with OCGA 50-13-4 A1 invalidates the amended rule. So
What's the citation? Is that, I think that you've cited it before, but
yeah, it's 186 Georgia App 550.
it was an older opinion than the one that Mr. Thomas cited. That's okay. I just 186 Georgia Appeals. The secret last few numbers?
550.
550. Thank you.
Yeah, and I'm happy to go on, but I think the court can sort through that unless it would like more argument on those issues.
I would like you or a colleague to share your thoughts about the claim that many local election boards countenance and engage in the hand counting of ballots already. And also your reaction to 483 really being a proper hook. Because I encourage you to skip past 483 when we were talking about the statutory authorization for the hand counting rule. But in reading it, I didn't read it in the way that Mr. Kaufman narrated it. I don't disagree. He didn't add words to it. I just hadn't thought about it that way. And so I'm curious if you have a response to either, yes, hand counting already happens all the time in lots of places, and then this 483.
Sure, Your Honor. And Daniel White again. This is where my history here. My firm's been representing this board for decades. When it was Democrat, then Republican, then Democrat. Like, so we've been doing this a long time. And I've got this history, and I know, and I pay attention to the history of these laws. And I kind of chuckled because when you were asking about purity, if you look at this is a different note, but if you look at purity, that was adopted in 1958. So the connotation of purity when that duty was adopted in 1958 may have had a little more nefarious or unpleasant connotation. So that's the kind of thing you have to pay attention to, is when did these rules come into laws get passed? So if you look at 483, 44, and 485, these are all adopted under the old form of optical scanners in 1981. The last update to them were in 1999 for all three, I believe, or at least one of that was the last update I saw for one of them. And so these were really adopted when you had optical scanners where you're marking it, hand marking it, it's running it through the machine at the precinct. And then, so you don't have a machine that's already doing a count for you when you put it in there. So they're going to count it again. And there were rules around when you're using that equipment from 1981 to 1999 before the direct recording machines came in 2000. There were rules around how you do that process, and those were interpreting 483, 484, and 485. Those have not really been, I think any of these have been updated to address the new BMD, the ballot marking devices, and the optical scanners that were adopted under OCGA 21-300, which requires uniform equipment throughout the state and authorizes the Secretary of State to basically go out and find the equipment and approve it and certify it and distribute it. But there's no doubt that these are opticals. I mean, that's what this is. It's an optical scanner. It's just that now the optical scanner has the count function built in. So we now have, before this rule came in, we had 4 counts already. You got the poll pad check-in, you got the BMD that's checking the number of votes that are cast on each machine, and you're going to get a printout from those machines. You got the memory card, let's go on to the scanner. The scanner is doing a count. It's going to have a memory card and a tape that it prints out. So really, that's just 4 counts right there. And then the process now, and you are asking lots of questions from Mr. Varghese about this, but for Cobb County particularly, those ballots, as they are under the current process, are taken. The write-ins are handled separately. The regular ballots are taken, put in the sealed container with all of the other materials, including the cards, the memory cards, and taken by the poll officers and a law enforcement officer to the central location. And so that's the current process that Cobb would have to change now before the November election if we're going to go with the new one. And so what this count that it's talking about is not a hand count. At that time it was, because they didn't have a machine that did it. But sort of the new equipment that's been certified by the Secretary of State says, we trust the machine count, and the canvassing that you get into in 493, that's where, you're bringing these back in these sealed containers. They're getting checked in. You're getting a receipt to the poll manager saying, you've given us 4 different counts from 4 different machines, and we're getting a receipt saying we've got these items. And then during canvassing is when the superintendent is doing this investigation of, looks like we had, this says we had 730 ballots, but really we ended up with 750 or 720. And why is that? And it usually is something totally I mean, it's like, well, we ran a test batch and someone forgot to reset the counter. And so there was 10 extra ballots. They didn't have any races on them. They're just some test ballots. So that's what canvassing is. What this new rule wants to do is it wants to have all of that addressed before the 11:59 deadline that on voting night that the secretary or the SEB has put in place in a different rule. So they want to say, we want you to do all that canvassing reconciliation and cram it in. We want the poll managers to try to figure out what went wrong and tell us why we should trust these votes by 11:59. Well, 4983 in the canvassing process that occurs before pre-certification and before certification the next Monday is where that process happens. And then there's a report given to the superintendent, and the superintendent takes that report and says, we've canvassed, we discovered these discrepancies. Every election director across the county is giving these reports saying, this is what we found during canvassing. What the SEB is asking you to do is to give us all that information before we report the results at 11:59. And that's unreasonable. It's not reasonable. And so that's when the Georgia GOP is citing to 43, 44, and 45 saying this is authorized. It's authorized, but it's already done. It's counted by the machines. Those 4 different counts that are done at the precinct level are then taken to the superintendent. And I want to point out 420, if you look at the structure of the statute, 420, it applies to all the different methods of voting. And you asked earlier, well, don't some counties still use paper ballots? They don't. Everybody has to use the same equipment. These are not receipts. These are ballots. So when they're counting, these are the ballots that they're counting. And so everybody uses the ballots from this equipment. And 420 governs all the different methods of voting. And so when these statutes are adopted, when the rules are adopted, they all have to comply with 420. And 420 says you do it as soon as possible. You get all the materials back as soon as possible, and you don't stop until you finish. And this rule creates an internal conflict with both of those, as Mr. Kaplan pointed out, that you're saying, well, slow down, don't do it immediately. And also you have the option of ceasing counting until tomorrow. So that rule in and of itself creates an internal inconsistency with 21-420, which governs all forms of voting at the precinct level and is still in place and was in place at the time that the new voting equipment was adopted. I did also, you asked questions about the current procedures. There are some counties that have runners who go get the memory chip and go take them to the central office. And then they do it, like you said, they do leave the poor poll managers there to do all the other work and close down. Cobb County doesn't do that, has not done that, has not budgeted for that, has not hired those workers, has not deputized them, has not trained them. So if this rule goes into effect in next week, we now have less than a month to do that. And that's why, in terms of Cobb County's irreparable harm, demonstration of, what's going, this is not ifs and buts. This is what's going to happen. And she's saying in terms of, Ms. Silas counts it in terms of concerns, because if we have to do it, we're going to do everything we can do to comply with it. But it looks to us like it's going to be pretty difficult to comply with it. We haven't had the proper time to train, to hire, to identify. So then we're talking about 444 people to count, plus now 100, because you got to have 2. We're going to have 148 times 2 plus security to go get the cards and run that and repeat that process with the memory chip. So we're being told now to do this. And just going to the ultimate question of reasonableness, Your Honor, and history, you asked us at the beginning, why are we not just slowing this down? As someone who knows the history of how these rules are implemented, these rules are typically implemented in off years and municipal elections. They adopt these rules. You do some test runs. Cobb County asked to do the test runs on this stuff all the time. Jenny Nevler, when she was our former director, was always saying, hey, we're going to do this. The Secretary of State's asked us to do this. You adopt them in an off year. You work out the kinks in a municipal election. And if for some reason you need to do it in a federal election year, you start back before the March and May and April primary. Like you start early and you say, hey, we're going to figure this out during the PPP, and then we'll know by the primary and it should work by then, but we're not going to do it. It's not reasonable to implement a rule 1 month before an election. And in this case, 2 weeks before an election after it's already started. So that's the history that I think Your Honor might not have been aware just from, identifying me as an expert. And I think that's probably an upgrade over what I would consider myself, but I've just been around long enough and seen this long enough that that's the normal process. And these rules that they're talking about that were adopted in 2020, that was COVID. And this was a brand new voting system that had been brought in 2020 without a dry run in a municipal election the year before, because we had a federal court say you better go get some new voting equipment. So we had COVID and new voting equipment in 2020. So you can kind of understand why there were some late rules in 2020. We've had this voting equipment for 4 years. There's no reason now that there need to be new rules implemented 2 weeks before Election Day. So I'm sure I lost track of your original questions there, but I was trying to give you some context for that.
That was very helpful. You answered all of them except for Mr. Kaufman asserting, trust me, there are lots of places that hand count ballots now. This rule is just sort of catching up with those in the vanguard. My words, not his, but are you aware from your work and talking with your election superintendent, if in what circumstances would there be hand counting other than that which is already contemplated when a discrepancy does arise from things that a superintendent is tasked with doing?
I'd really be probably a better question for Director Fall, but I can't say, we tend to converse along the larger counties. I mean, you'll see a lot of the questions being raised are by the larger counties because we have.
It's more complicated.
It's more complicated. We have more problems to deal with, but among the larger counties, I'm not aware of it. There may be some smaller counties. And under 43 and 44, like if you see in 45, there's like a distinction between people that can't tabulate at the precinct versus the tabulating center. That's not really a thing anymore because we all tabulate through the machines now. But there may be some discrepancies about who counts at the precinct versus who counts ballots after they return them to the tablet, which we do. I mean, there's just no doubt that these get counted when they get back to the tablet. It's just they use a machine, which is more reliable. And then if during the canvassing and during the audit, if there's discrepancies, that's where it comes in. And so and there's a lot of different ways that they could ask for a hand count and put it during the canvassing or other things that would have been reasonable. But that's I'm not aware. That's short answer to your question is I don't know, but that other people may have those conversations that I'm not aware of. And it's not in the record that I've seen.
Nope, it's not. All right. Thank you.
Your Honor, would it be helpful for me to briefly clarify what the status of case law on whether amendments must follow the APA notice requirement? Happy to be told no, but.
Well, I guess that there's a dispute, and the newer case that was cited to me said it does not apply to amendments. Do you have something newer than the
advertisers?
Well, outdoor advertisers, at least the citation I was given, made it older than the case
Right.
Mr. Thomas cited.
Right, and no, I don't have something newer, but I want to clarify what those two cases say.
Okay.
Outdoor advertisers says that 5013-4A does apply to amendments. What Coroner later says is that it talks about a specific amendment. And what it says in that case, what happened is the amendment did not state the statutory authority of the rule. And petitioners sought to invalidate it on that basis. And the court said, well, it's the statutory basis of the rule and it's the amendment, and the rule itself outlines the statutory basis. So under those specific facts, the public was apprised of everything it needs to know.
Okay.
That same analysis does not apply here.
I'll need to read both cases, but that's a helpful distinction. Thank you. No one else should stand up because we're done. I want to thank our court reporter first for taking all this down. And then to all the lawyers and the folks supporting them, this was a mad dash to get here today. That's not anyone's fault. Things are happening quickly. The state election board has been working hard to move forward in the ways it thinks is the right way to make elections fair, legal, and orderly. Some of the steps they've taken, the majority has taken, other folks disagree with, and lawsuits have followed. So we're here because we work things out in courts and not with coups and other things like that. But it has been hectic, and I appreciate everyone's work to be ready, in particular, my friends from Burr and Foreman, because this wasn't on your radar at all until very late, and you've been working on other cases. Fortunately, similar issues, so I'm assuming it wasn't too complicated to pivot, but it was still a rapid pivot. And Kaufman and Kirchhoff, you guys just parachute into all cases now, so you're sort of the shock troop. Same with our interveners. But this has been very helpful. This is an important situation. And I will work to provide a little bit of clarity today, and then we'll see where that takes us. And I guess some of you will then need to navigate what that means for tomorrow at 2. And things will flow from there. Does anyone have a procedural? Oh, I was asked to ask, are there defense exhibits that you meant to admit, or maybe there was this overall stipulation? Mr. Kaplan waved around the giant binder, and Mr. Thomas, you said we don't object to that. And I know we got the plaintiff interveners exhibits were admitted. I want to make sure the record contains your exhibits as well.
We did submit those. There were only 2 exhibits. They related to the statistics from the 2020 and 2022 elections.
Yeah, I hope they're not objected to, because I looked at them last night. That's how I knew where you were coming with hey, most of the votes aren't even on election day. No objection to defense 1 and 2.
No
Okay. And Mr. Kaufman, you're free to supplement through defendant interveners exhibits if you get your hands on copies of those agendas, but run them by counsel first so they can be comfortable that that's not something you just ginned up in Adobe or something like that. Okay.
I'm not that technologically savvy, as the court knows, but
Yeah.
we'll have those sent out. We have them already. We'll email them as soon as
Okay.
we adjourn.
Sounds good. Mr. Kaplan, anything procedurally from your client?
No, nothing else, Your Honor.
Okay. Anything from the plaintiff interveners?
No, Your Honor. Would the court like paper copies of the exhibits we admitted?
We have them digitally. We're good. Thank you. Mr. Thomas, anything else on behalf of the State Election Board?
Nothing further.
All right. Thank you for your work. Mr. Kaufman, anything else?
Just I would proffer that to my knowledge, it's Hall, Forsyth, and Paulding County that do the hand count, because I never got that out to the court, but that's.
Right. And what does that mean? They do a hand count, that they will, despite what all the machines say, they also make sure if the total vote in Hall County was 100,000 people voting, they make sure there are 100,000 paper ballots, or only when something funky arises?
No, my understanding is they count the number of ballots at the precinct before they send them off as per the rule.
Okay. All right. Thank you. Someone needs to settle up with the court reporter, and I will be in touch. Thanks for your time.